on behalf of Mr. K.M. Halle, I beg to mention item number 37. Is suffering from certain equipment harm. Kindly matrimonial action for that. Item 37. Is for the respondent.
But
I'm not sure. I'm for another line.
the other side,
Yes, my lord, we have consent.
May please, Lordship. Lordship, I beg to mention item number 19 of today's daily list, Lordship. Lordship, I am for the appellant. We are awaiting some instructions in the matter, Lordship. So it may be adjourned. Much obliged, Lordship.
The two steps are other side. Item for 45. Item number 45, they have state of India, they have filed the IA extension of time. Comply with the lordship judgment dated. Now they have complied with the judgment. The IA becomes.
you have for
I am for the petitioner respondent. My name is not. For the class of serial number 2, Muhammad Ansari.
petition is disposed of.
Allowed.
Heard Mr. D. Bora, the learned counsel appearing on behalf of the respondent. Where's the union?
I've been told that they had a variation in the package. So it might-
With here. You can get hold of any union council. Just at any point of time, you just get hold of them and pass the order in their presence because it's their application.
Yes.
For me to close it, that they have complied would not get hold of anybody. Or Mr. Bora at 2. Get hold of anybody at 2.
Mention item 44, please. As for the respondent, I'm appearing on behalf of the what is it, some time to file the objection?
Hmm?
We need some time to file the objection for this.
What object?
The
We'll look
IA,
at
IA 1030
what is this objection about.
for grant of air interim injunction notice. One by the order dated 10/5.
Okay, we'll look at it at the time when the matter is called up. Ms. Purva, in this matter, you have filed an application for the purpose of seeking extension for complying with the order. Item number 45. The learned counsel out here submit that the order has already been complied with. We'll take it up at 2. Just take your instructions on that. Okay. Yes, item 1.
Item number 1.
So let's see.
And there's a finding below. Put below that there is no sense of yes.
There is a tenant with respect of method. In February 99 method, agreement court, there was entered
phone number 1A, my lord. It's number 1A.
Where's the plane?
Plane that is 6.
Page 6. Okay.
My lord,
Agreement for sale entered into between
between, my lord, this all these, my lord, defendants, 1A to D. But the deed was
1A
signed by
to D in favor of
in favor of the plaintiff,
all.
my lord.
1 to 3.
1, 3. So their attorney, and it was signed by the 1A. 1A. It is 6 months, my lord. Yeah, shall it be checked? Shall it be accepted?
Ah.
And the consideration was 4 lakh. But subsequently, my lord, in July, you can know, my lord, the same person, my lord, he sold the land to at 4 lakh.
Okay. Then
we filed a suit, my lord.
Mr. Thor, that day I picked that matter
My lord, yes.
on 29th, and I
There is a holiday, my
told
lord.
that it is a holiday. We'll have
Exactly,
it
my
on 30th. 30 is closed, open.
Open, my lord.
Okay, we'll have it on 30.
My lord. So in this regard, my lord, I'm just making a mention.
We'll take it up at 2.
My lord, my lord. Take it open.
The salary was also executed by Stephen number 1A, my lord, for himself and for others on the rest of the power of attorney. But the power of attorney was neither produced nor spoken. And salary is also, my lord, the only certified copy of the salary was original.
Who executed the sale deed? Defendant number 1A in favor of the defendant number 2.
And he executed it on his own behalf as well as on behalf of defendant number 1BCC on the basis of a power of legal state. But power of attorney has not been produced by the court, nor it is. And original sale deed was also not produced by the court. Only a certified copy was produced, and defendant number 2 says that original sale deed is in hand. Now, we have challenged that file of the sale on the basis that just for some extra amount, because 4,50,000 or the consideration amount to take.
So your suit was for specific performance,
So it's performance and
for cancellation of the sale deed which happened subsequently.
And there
But you duly admit
yes,
that there was a sale which was being made by the defendant number 1A to the defendant number 2.
well, because the notice was issued by us, so that is why we have come to know that sale deed has been executed.
So therefore, if the sale deed was executed,
Yes.
you admit to that effect.
But our agreement for sale was prior in time, by the
That is another aspect of the matter.
That
The
is it.
fact that the defendant number 1A sold it to the defendant number 2 is admitted by you.
Because we have not seen that, my lord. Only in the court, my lord, that sale deed has been put in.
Okay.
Well, the certificate copy of the sale.
But are you not challenging the sale deed?
That is answer.
So that means you admit
Yes.
that there is a sale
My
deed.
lord, yes, that's
So the
excellent.
merely the certified copy being produced, and did you put an objection at that point of time? Did you
My lord,
put an
in that
objection?
cross, my lord, we have said, my lord, that the original sale deed, well, he said, my lord, that the originally to be given.
Well, that is there. So that aspect is there. Now only therefore the question is as regards whether there could have been a specific performance of the agreement.
Right.
Now the agreement was executed between you are the plaintiff, by the defendant number 1A.
Number 1 ABCD, but it was signed by different number 1.
So defendant number 1A, so you therefore admit that the defendant number 1A had the authority over the defendant number 1BCD, because otherwise your agreement is also useless.
They are residing in Rajasthan, my lord. Later on also, my lord, they state, my lord, that from Rajasthan they have issued the power of attorney.
Now the trial court, what did the trial court?
Trial court, my lord, they will find, my lord, because this salary, my lord.
There is a counterclaim also.
My lord,
There is a counterclaim.
counterclaim also, my lord, that regarding defaulter and my lord, and that.
You were a tenant. Okay. So what happened to your suit? Your suit was dismissed.
suit was dismissed and appeal was also
Appeal was dismissed. And the counterclaim was allowed.
counterclaim.
So this appeal is against which?
Hello?
This appeal is against what?
For both matters. It's a common judgment.
Can you do that?
The only question of 40 matters. I can.
Now let us see. In that backdrop, what is the reason why the first appellate court, the trial court dismissed your suit?
Dismissed, my lord, my suit, my lord, it was said that because on my behalf, my lord, attorney signed the agreement. But the agreement is a unilateral document, my lord, our High Court has judgment. That's enough to one.
Huh?
It's a unilateral agreement, my lord, as by our High Court. Sometimes, my lord, even if signature is not there, then also, my lord.
So what is the reason why the agreement was not
Yes,
given?
your lordship may
Let
come
us
to,
see
my
the
lord,
trial court
trial
judgment.
court, yes. Issue number 3 at page 39, sir.
Page
39.
trial court judgment. The civil judge senior division.
This is the, my lord, the agreement that has been quoted, my lord, yes.
Let us see the issues involved, whether the agreement foretells the property with the petition for 182 Purana. Okay, then it continues. Against this, here. The agreement has been quoted. Is the original, there's a lot of mistakes. Original judgment
Yeah.
of the trial court. Hey, सुनो से. Yes, Mr. Sayola, have you read the grounds of appeal in the first appellate court? Have you really read it? Let me. Ground number 6. This is interesting. For that, though the civil judge was to adjudicate two suits, one of the plaintiff and the other of the purchaser, and though the two suits with equal status have their respective burden of proof, the civil judge gave prominence over the adjudication of the plaintiff suit and disposed it by a single issue of unenforceability of a sale contract and placed the suit of the purchaser in the twilight of sunset, with rapid fall of the darkness. And thereby he made the suit of the defendant purchaser obscured and opaque, without disclosing the real picture of the counterclaims and its objections by the plaintiff and the defendant thereupon. A suit for declaration of eviction, fair correction of records, and for injunction was made for a declaration of right, title, and interest over the purchased land, for declaring the plaintiff to be a defaulter and liable to be evicted, and for remand by conscious hiding the claim of fair rent at the rate of rupees 2,000 per tenant till eviction, and other infirm relief by a person who very titled by against which the plaintiff challenged the legality. My goodness. And he writes it as a poem.
Poem. Well, I have seen that just now.
Isn't it, Mr. T?
It is just like a poem. Right.
He puts all the grounds like a stanza.
First time I have seen fellow.
Huh?
First time I have seen.
So the issue number 3 is the relevant issue.
It's number 3. Because
Now let us delve on the where is the
we have focused on the part of the land.
I'll nine here. Nine.
We are focused on in part of the.
Let us read issue number 3.
Yes. Agreement has been quoted here.
Let's read issue number 3. The PW1 after the agreement. PW1 when
Yes, what knowledge of careful with that. This not.
If it, P. P is a deed of agreement by Banwarilal Dr. Surana,
Surana.
situated at NH and Narendra Kuar, Haridam
First attorney
Kuar,
on
and
behalf of
Prahlad.
Rashmiti Bolcha and Haridam Agarwal for booking cases. That's the
Now let us see who are the plaintiffs out there.
plaintiff Malate Sijada Rashmiti Bolcha, then Narendra Agarwal,
Hariram Agarwal is there
Haridam.
and Prahlad Chandra Das. But the others were not parties.
Hello?
Plaintiff number 1 was not a party to that agreement.
No, it was Malate because the attorney signed.
No, no, but then also in the attorney agreement, there has to be a mention. Have you looked into that agreement? Huh?
Agreement there is no.
Agreement is between Narendra Oswal, Hariram Agarwal, and Prahlad Chandra
But in the
Das.
signature Malate is there.
No, they are there. But the Rashmi Devi Golsa is not there.
No, it was in the signature also it is mentioned.
Huh?
One on behalf of Rashmiti Bolcha, Narendra Agarwal,
Where?
and the signature. Signature.
But the agreement, you have to read the agreement.
Hello?
The agreement does not say this is between Rashmi Devi Golsa. There's not a single mention of the.
Malate, the Khan Malate has name is there, son of the people.
So son can very well he can be a very well a party to the suit. But this is an agreement between so and so and so and so.
That's not mentioned.
Huh?
That is not mentioned in that first title.
No. Has it been anywhere mentioned that he is signing on behalf of there's a stamp out there. He has just put a stamp out there. Nothing more than that. Huh? Maybe, but this agreement is between Banwarilal Agarwal, Surana, and Narendra Oswal.
Haridam Agarwal and Prahlad.
Hariram. Now, Hariram Agarwal happens to be the plaintiff number 2A.
And see the Prahlad.
And during the pendency of the suit, the plaintiff, this person concerned, became plaintiff number 3, Prahlad Chandra Das, who was originally the performer defendant,
Yes.
was transposed and made plaintiff number 3.
Because he was also a party to agree.
But while deciding issue number 3, the court did not take into account the evidence of the case of the
Right.
plaintiff numbers
2 and
2,
3.
plaintiff number
12.
not 3, 2A, 2A,
2A and 3.
2A and 3. Now,
That's it,
did they use evidence?
my lord.
Let us see. Who has reduced evidence? PW1 happens
Not
to
in
be
my lord.
no.
Then Sairam Agarwal is P2.
Huh?
Sairam Agarwal P2.
Go to 2E. PW3 is Prahlad Das.
Yes. Is that
Here I gave it.
so today
The agreement was entered into by one Banwarilal Labsan Surara, MS. It's a firm.
because that was the farm.
Who was the owner of the property?
The four farm.
So how can a firm enter into an agreement?
No, it was signed by my lord, the
That's a different thing. But this was not done by any person. It was done by some firm. The first party is the owner of 2 kathas, 16 letters of land under dark numbers 2 and was the first party the owner, the firm?
four brothers, my lord, the owner. 4 brothers are the mother part.
But it is the firm who has done it.
Farm, my lord, this is the farm, but he depended.
But did the firm have anything to do with the property? No. Whether the land was in the name of the firm or whether the property was brought within the ambit of the firm.
But because my lord, ultimately, it was stated also. He stated Captain Surana and attorney for Galton Surana, Captain Surana.
Yes, Mr. Bay. So you don't have anything to say. The decision of the trial court in issue number 3 is not so pleasing. But the fact remains that the agreement was done by some firm and the firm was never the owner.
That has been in the judgment of the court below also.
Where?
It is trial court judgment as well as
Trial court judgment is silent on that.
it is there, my lord.
Trial court judgment, that is what I read it. Couldn't find anything. I wrote tail on that. Where is it?
My lord, page number, sorry, my lord, I cannot say the page number in the memo of appeal, my lord. It is issue number 3, last part, my lord. That
Issue-
part, the trade agreement exhibit, issue number 3, last part.
Further reveals that so and so is the executor as the first party to the agreement,
My lord.
but there is no citation in the agreement that the defendant number 1 are represented by the defendant number 1A.
My lord.
The admitted position is that the suit property is jointly owned by defendant number 1A to 1D.
My lord.
But where is the admission? How could the trial court come into that finding? The defendant number 1A had any role? Who was the defendant number 1A? Let us see.
Number 1A is the Lokchan.
Huh?
Lokchan Surana.
So Lobsan Surana.
Lokchan Surana.
So
There are other 3 brothers also.
understood. So Lobsan Surana, but the agreement was done by some firm.
Farm is not the owner of the property, my lord.
So whether if the firm is not the owner of the property, was it? It must have been a partnership firm.
My lord.
At best,
My lord.
because there were 4 persons.
My lord.
And if it was not, if it was a proprietorship firm, it couldn't have been a proprietorship firm of more than 2.
My lord.
It has to be a partnership firm. So if it is a partnership firm, wouldn't that then all the partners have to be made
My lord.
and has been made. But if it is not registered, wherein did it again 69? What was the state of the firm? Whether there was a firm or not? And how did the firm execute unless the property is with the firm?
My question is, that is also my question, my lord.
Oh.
Farm cannot, my lord.
Then why it was never raised at any point of time? Here the court says that 1A was the owner. How can the 1A be the owner?
1A is not the owner.
Yes, 1A may be the owner, but who had executed the deed? Deed was executed by so and so. Let us see what does it say about in the plain. It says the defendant number 1, by virtue of purchase in 1977, became the landlord of the aforesaid land of Schedule A.
My lord.
What is this deed? Have they exhibited the deed?
That deed has not been
Hmm?
executed, my lord. Defendant number 1 by virtue of purchase in 1977 become the landlord.
Here the reply is, it is defendant number 1A and defendant number 1D who had jointly purchased the land, not defendant number 1. There's a difference. 1A and 1D could be different. They are individuals. Let's see how does the appellate court take into consideration that. Number 3.
Page 54.
Kindly come,
depending
Mr.
on-
Day, kindly come to page 55, the last paragraph, paragraph 32.
The appellate judgment matter.
The memo of appeal. You have the memo of appeal with you.
Sorry, Mallory, it is not. I did not find time to arrange it, Mallory.
Okay, paragraph 32.
Appellate judgment 32. I am happy.
Yes.
It is also found from Exhibit 3 that Mrs. Bhanwari Lal Lobsan Surana was third party to agreement, but on careful perusal of said agreement, Exhibit 3, it is found that the defendant number 1B to 1D are represented by the defendant number 1A, and the suit property is jointly owned by defendant number 1, but the agreement of sale executed only by defendant number. There is no evidence that the defendant number 1B to 1D were represented by executants, defendant number 1A. Under the above circumstances, the defendant number 1B to 1D are not bound by the agreement Exhibit 3, as because co-sharers did not authorize defendant number 1A for execution of Exhibit 3.
How did the court come to that finding?
Mallory, Exhibit 3, Mallory, Exhibit 4.
No, let us see exhibit 3. Find out a single line which shows that he is representing himself or the defendant.
Nothing is there.
But how did the first appellate court come to that finding?
Then also it is said that there is no the defendant number 1A is not represented by 1B to 1D. The lot is seen, Mallory.
It is also found from Exhibit, but the agreement of sale was executed only by defendant. There is no evidence that the defendant number 1B to 1D were represented by executant defendant number 1A.
This has also been.
No, not only that. Where is it shown that here it says are represented by defendant number 1A, the plaintiff, the property jointly owned by defendant number A, but the agreement for was executed only by the defendant number 1A. Then if the defendant number 1A had executed it,
What?
can't there be a specific performance in so far against him?
Well, agreement, it is shown that I have denied them. Defendant number 1A has denied the execution of the agreement. Well,
That is a different. I am not on that. That is the final finding.
Right.
But if the defendant number 1A had executed,
The property is a joint property, belongs to defendant number 1A to 1D. The sale deed has been exhibited at exhibit 4 by the defendant number 1A himself. Exhibit 4.
what exhibit? Exhibit 4 is no document. Exhibit 4 is some chalan. Chalan. As exhibit, which is submitted exhibit 6. Original, exhibit 7. It is being done by
No, it is exhibit 7. I think
execution is admitted and the so constituted attorney of so.
the exhibit 7 is the sale deed by which the property defendant number 1. All the
You are
four-
appearing for whom? You are appearing for whom?
2 and 3 man.
Who are the purchaser?
Purchase.
You are trying to protect you.
Man.
Who is appearing for the main people who have caused the agony to Mr. Sahewala's client? Eh? Reading the memo of appeal, it gives me such feelings.
Well, your get-up is also very stylish.
No, he has exactly put it like a prose. Now let us see questions of law.
What a harm it takes. Yeah.
Agreement for sale, whether the findings of the court below that there was no evidence of defendable. When was the agreement for sale executed? The exhibit 3?
Exhibit 3 of
6th of February 99.
99.
And when was the other deed of sale executed?
it was in,
In September 99, I think.
no, it was in May 99. May 99. 6599.
$23,499.
Tell me,
Power of attorney. The Savala, you had a case, you had properly looked into the sale deed. The sale deed, otherwise, I think it would not be proper on my to comment. Uh, see, Section 32 of the Registration Act stipulates what type of power of attorney is to be for executing a registered. But that is not a point which you can raise in the second appeal now. This is a notarized power of attorney. Can a notarized power of attorney execute the registered deed of sale?
Power of attorney has not been produced.
No. The date of the power of attorney is 23/4,
Yes.
which is after the agreement for sale.
Yes.
Obviously, you can't say that. So your first question of law goes. You had a case, but that has not been. Kindly see the registered deed of sale. Read the second page.
Yes,
Whereas the vendor, so and so and so and so, now residing in the state of Rajasthan, appointed their own brother, so and so, above as the true and constituted attorney for self and so and so, and the lawful attorney to sell the land at Dhupri by notary Nagaon on 23/4/99, which is after the deed of agreement.
Yes.
So that first question of law goes, you don't have it. Whether an agreement for sale executed by a co-sharer is not enforceable in respect of fees This also can't happen now. How can you have this number 2?
Section 44.
44 is there, but who has executed the deed of sale? The agreement for sale. It is done by the firm.
That's the IPF matter. IPF. That's the IPF.
In your plaint, he says it is said to be a proprietor. See your plaint. However, you describe one.
Notice says that they are IPF. So because rent receipts are in the name of that
If you see Exhibit 7, it categorically shows that it is owned individually, jointly by all.
Correct.
So how can, if it is done by a firm
rent
or
receipts are
HUF,
in the name of
can the HUF enter into an agreement for sale? It can't. Unless the property is brought within the fold of the HUF. Otherwise, it will happen and serious consequences. He will, if it is a HUF, then the question would have been, your case would have been different. That is never your case at all. You would have said that he executed as a karta, which you have not. That is not your case. Whether the rent deposited in the joint names of so and so is not valid in the facts and circumstances. Yes. What about the other one?
That is what because we have tenant of tenant we have deposited a rent in both
Where?
name of both parties. In both.
Have you not tendered the rent to him?
Because we approached them, they refused and thereafter we have started.
Let us see your evidence where you have stated, you have approached. Show me that.
Well, right. My lord, first PW1, my lord, page 4 is the notice, para 7.
Of the chief. Let us first see your claim, because they have, it will be in your written objection. Written statement of the above named defect one. Written statement of the where is your written statement to the counterclaim?
Yes, my lord. 30. 30.
Additional written statement that yes, where have you mentioned
Evidence, my lord.
being the affair for the where you have stated you have deposited. Kindly see paragraph 12.
My lord.
Just in the plain, have you stated anything?
That's absolutely. That 13 melatonin is depositing land.
That by virtue of the fraudulent purchase of so we have not mentioned that you fulfill 5-4. You can't merely deposit in the court. You have to file a. If you want, you could have filed an interpleader suit or whatever may be. Here, you do something else, but you can't just deposit in the court. Or under protest, you have to deposit. And in whose name are you depositing? After the letter of atonement was given under 100.
Joint name. Joint name.
Joint name of?
Joint name of the point of the harm as well as that you cannot.
Two. Heard Mr. G.N. Sahavala, the learned counsel, senior counsel, assisted by Ms. Esther. Mr. Tikiti, the learned counsel, appears on behalf of the respondent numbers. Respondent number 2. 1 and 2.
2 and 3.
No, 1 and 2. Antona De and Papum
Yes,
Kumar De.
yes, sorry, 1 and 2.
1 and none appears on behalf of the respondent number 3 on court. The instant second appeal was admitted by this court by formulating the following substantial questions of law. By an order dated 22/5/2012, which are reproduced here in under. 1, 2, 3, 1, 2, 3. Actually, there are 3. They are royally wrong. 1, 2, and which are mentioned, expected. For deciding the said dispute, for deciding as to whether the 3 substantial questions of law as formulated by this court arises in the second appeal in question, in the instant second appeal. This court deems it proper to refer to deal briefly with the facts involved. From a perusal of the plain, the parties herein are referred to in the same status as this suit in the trial court. It appears from the plain amended plain as enclosed to the instant memo of appeal. There are plaintiff number 1 and 2, where tenants of the original owner of the Schedule A land as described to the plaintiff. In the year 1977, the said land was purchased by the defendant numbers 1A, 1B, 1C, and 1D. And the plaintiffs, number 1 and 2, continue their tenancy under the defendant number 1 as alleged. It further reveals from a perusal at of paragraph number 4 of the claim that M.S. Bhanwarilal Lapchand Surana, a firm wherein the defendant numbers 1A to 1D were partners, entered into an agreement for sale with one Narendra Oswal, comma, Mr. the comma the plaintiff number 2A and plaintiff 3 number 3 for sale of a plot of land measuring 2 kata 16 letter under dark number 391 and 987 of periodic patta number 35 at ward number 4 at Dhubri town for a consideration of rupees 4,50,000. It was also clause 3 of the said agreement dated 6th of February 1999 stipulated that the registration shall be made within 6 months and the payment shall have to be cleared at the time of registration, failing which the agreement shall be deemed to be cancelled. It is, however, the case of the petition plaintiffs that during the pendency of the said agreement for sale dated 6th of February 1999 by the defendant numbers 1A to 1D fraudulently executed the deed of sale in favor of the defendant number 2 and 3. And the defendant number 2 and 3 had due knowledge of the said deed of sale, of the agreement for sale dated 6th of February 1999. It is under such circumstances the suit was filed seeking specific performance of the registered deed of sale specific performance of the agreement dated 6th of February 99, as well as for declaration and cancellation of the sale deed number 887 dated 6/5/99. 65 or 687? Huh? 65. In some other places you have mentioned something else. 65, huh? আগতো ভুল এটা হৈছিল 87 কৰি আছে 6599 it reveals from the records that initially at the time of filing the suit the defendant the plaintiff number 3 was the pro forma defendant number 2. But pursuant to the filing of the suit, the pro forma defendant number 2 was transposed as the plaintiff number 3. It further reveals from the records that the defendant numbers 1A to 1D filed a written statement wherein various preliminary objections were taken. In paragraph number 17 of the said written statement, it was mentioned that the land in question was purchased by the defendant numbers 1A to 1D jointly. It was further denied in paragraph number 19 that the defendant number 1A entered into any agreement or took any advance from the plaintiffs. It further reveals that the defendant number 2 and 3 had filed a separate written statement wherein also various preliminary objections were taken as regards the maintainability of the suit. In addition to that, it was also mentioned that the defendant number 3 was a bona fide purchaser for valuable consideration and comes within the ambit of Section 19B of the Specific Relief Act. Was a bona fide purchaser for valuable consideration without prior notice to the agreement dated 6/2/1999. In paragraph number 18, it has been mentioned that the plaintiffs were duly intimated by the defendant numbers 1A to 1D about the purchase of the suit land by the defendant numbers 3. However, the plaintiff number 1A to 1D, instead of tendering, attorneying to the defendant number 3 on their own, started depositing the rent in the court in the name of the defendant number 3. It further reveals that a counterclaim was also filed by the defendant number 2 and 3, whereby it's the defendant number 2 and 3 sought for declaration of their right, title, and interest over the Schedule A land semicolon, for a declaration that the plaintiff were tenants under the defendant number 2 and 3 for the properties as described as Schedule E and F of the counterclaim, and that they are defaulters and liable to be evicted under law, etc. It reveals from the records that the plaintiffs filed a cross objection to the said counterclaim. Relevant herein to take note of paragraph number 12, wherein it has been categorically mentioned that the house rent have been regularly deposited in the court, and as such, the question of defaulting in payment of rent, house rent, does not arise. And the ownership as stands remaining suspended. The counterclaimant cannot claim their right of house rent from the original tenants. On the basis of the above, as many as 7 issues were framed by the learned trial court. Page 38 of the book. It further appears from the records that on behalf of the plaintiff, how many witnesses? 2, 3.
7.
Plaintiff?
7.
7 witnesses. Anything. It further reveals that on behalf of the plaintiff, there were various witnesses who adduced evidence, and the plaintiff also exhibited various documents. On behalf of the defendant also, there were various witnesses who adduced evidence, and various documents were also exhibited. This court finds it relevant at this stage to take note of that Exhibit 3 is the agreement for sale dated 6/2/1999, and Exhibit 7 is the deed of sale. Is the agreement for sale is the deed of sale dated 6/5/99. The trial court dismissed the suit by the judgment and order dated 31st of August, judgment and decree dated 31st of August 2009. In doing so, the learned trial court came to a finding that Exhibit 3 was not enforceable. As regards exhibit number 4 and 5, the learned trial court came to a finding that the plaintiffs were defaulters in payment of rent and therefore are liable to be evicted. Being aggrieved and dissatisfied, an appeal was preferred before the court of the district judge Dhubri, which was registered and numbered as title appeal number 5/2009. At this stage, this court also finds it relevant to take note of that as the suit was dismissed and the counterclaim was decreed, was dismissed and the counterclaim was decreed, the appellants, the plaintiffs ought to have preferred 2 appeals. However, only 1 appeal was preferred before the court of the district judge Dhubri, which was registered and numbered as title appeal number 5/2009. It appears from the records that the first appellate court, by the judgment and decree dated 6/9/2011, dismissed the appeal, thereby affirming the judgment and decree passed by the learned trial court dated 31/8/2009, passed in title suit number 12. It is against this, the judgment and decree passed by the first appellate court dated 6/9/2011 in title appeal number 5/2009, the instant second appeal has been filed. As above noted, by the order dated 22/5/2012, this court had admitted the instant appeal by formulating the 3 substantial questions of law. The first substantial question of law pertains to as to whether the finding of the courts below that there was no evidence that the defendant number 1A was representing their defendant numbers 1B to 1D is correct in view of Exhibit 7, that is the sale deed, where the defendant number 1A executed the sale deed as a constituted attorney of the defendant number 1B to 1D. From a perusal of the said question of law so formulated as a substantial question of law, it appears that it is primarily a question of fact. No, it is not only a pure question of fact, it is neither, it is primarily a question of fact. Be that as it may, a perusal of Exhibit 7 clearly shows that the said Exhibit 7 was executed on the basis of a power of attorney dated 23/4/1999. Which was executed, meaning thereby the said power of attorney was executed after the deed of agreement for sale dated 6/2/99, Exhibit B. And therefore, the said question of law so framed, in the opinion of this court, is not a cannot be termed to be a substantial question of law arising in the instant appeal. As regards the second question of law, substantial question of law, so formulate as to whether the agreement for sale executed by a co-sharer is not enforceable in respect of his share of land. In the opinion of this court, same line, is not a substantial question of law arising in the instant appeal. Inasmuch as the agreement for sale dated 6/2/1999 was executed by a firm and not by the defendant numbers 1A to 1D in the personal capacity. And as such, there is no document which could be shown that the firm MS Bhanwari Lal Labchand Surana was the owner of the Schedule A land, was the owner of the scheduled land, suit land. Under such circumstances, the said agreement, the said substantial question of law so formulated in the opinion of this court does not arise in the instant appeal. The third substantial question of law so formulated was whether the rent deposited in the joint names of the defendant numbers 1 to 3 is not valid in the facts and circumstances of the case. In the opinion of this court, it also cannot be taken into account as a substantial question of law involved in the instant appeal. In view of the fact that for the purpose of getting the benefit under Section 5(4) of the Assam Urban Area Rent Control Act 1972, so that the plaintiffs do not come within the fold of the Proviso E to Section 5(1) of the Act of 1972. The tenant is required to offer the rent to the landlord and it is upon the refusal of the landlord, the rent could be deposited in the court. The lawful rent could be deposited in the court. There was no mention whatsoever in the pleading that there was offering of the rent to the defendant numbers 2 and 3 pursuant to the letter of atonement issued by the defendant numbers 1A to 1D. Under such circumstances, the learned trial court as well as the learned first appellate court have therefore come to a finding of fact that the plaintiffs were defaulters in payment of rent. These findings of fact therefore cannot be disturbed in a proceedings under section 100 of the code. Under such circumstances, the third substantial question of law so formulated does not arise in the instant appeal. Accordingly, as no substantial question of law arises in the instant appeal therefore stands dismissed. The registry is directed to prepare the decree to return the LCR. Big file goes from the court.
For admission item number 2.
Just tell me. You're challenging what?
Challenging two orders, Your Lordship. Actually, the petitioners, the predecessor was the defendant. And ex parte order was passed, Your Lord. And the predecessor filed an application under order line rule 13. There was delay. Along with that order line rule 13, section 5 petition was preferred. That was dismissed. Thereafter, appeal was preferred. That was dismissed. Against those orders, the petitioner preferred.
Decree passed.
Lord,
Party decree.
decree for ex parte decree.
Decree for what?
Evict.
Have you been evicted? Have you been evicted?
Not
Yes, my
decree.
lord. Decree was executed.
Evicted?
So far, my instruction, they are.
My lord, the decree was executed, my lord, on 16/11/2022, my lord. Thereafter, my lord, this honorable court, my lord, issued notice on 21/11, my lord, 22, my lord.
There is no interim order which can be extended. The decree has already been executed. You have the paper?
Thereafter, my lord, again, my lord, on 24, my lord, 11, my lord, I was dispossessed, my lord. Please, my lord.
Executing court proceedings have been stayed. Where it is, And thereupon, what happened? What order was passed pursuant to this report, which was given on 24/11, 22/11?
That report was accepted by the court, my lord,
Where is the order?
on 22, my lord.
Where is the order? Which district? All.
Hold on.
Have it?
That order I have not got.
What is your ground, Mr. Tom?
Okay. The limitation petition.
When was the decree passed?
Decree passed Lordship 31/3/2014.
31/3/2014. And when did you file your application under Order 9 Rule 13?
7/3/2015.
7/3/2015. 31
3/2014.
after 1 year.
About after.
Almost one. 7/3/2015. Okay. What was your ground? There was a delay of
Delay of about
311 days.
Page 55, your lordship, delay petition.
Hmm?
Page 55, your lord.
Did you receive the notice summons?
Yes, lordship, I filed my appeal.
You filed your WSO. Thereafter, you did not participate.
Lord, did not, but lordship, this statement.
What about your lawyer?
This statement, my lawyer expired, lord.
When?
That was during pendency, lordship. I have explained in my ex parte vacating petition, your lordship. Kindly see page 49. Page 49, from paragraph 1, your lordship, there is explanation, and
But have you not challenged that the order passed in the appellate order? What are you challenging here?
both the order.
I think we should have to call the records of the suit.
Yes.
Hmm? Heard Mr. A.R. Shom, the learned counsel, appearing on behalf of the appellate of petitioner. Mr. T. Islam appears on behalf of the respondent. upon examining the facts involved and the allegations were made in the petition to the effect that during the pendency of the suit, the case was transferred to another court and there was no notice issued to the petitioner. And it is on account of that the suit was decreed ex parte. This court deems it proper to admit the instant petition. The records of both of title suit number 21/2010 as well as the records of Miss Appeal number 6/2017 be called for by the registry for which list the matter for further consideration on 27th of July 2023.
Okay, are there
What interim order? You have been already.
Item 3.
how long you?
Yes, what you are challenging, Mr.
I have prayed for recasting of the
Huh?
recasting of the issue for the drawer court.
Then what happened?
The issues, then the learned court below rejected the prayer in the sense that I prayed for specific insertion of one issue and deletion of another. Those were not. I'll just take your lordship to the fact first.
Where is it? Where is your application?
The application is at page 43, annexure 5.
Page
43, annexure 5. The issues framed, already framed, were are given under the paragraph 2 your lordship. And the proposed issues are in the next page.
What was the stage?
It was the PW was not started yet. PW was
PW was not started. Issues were framed on 13/7/2022.
this was petition was filed on
Well, you were the plaintiff.
defendant. I just briefly take a look at the facts.
No. Whether the defendant is a defaulter in payment of rent, whether the defendant who premises is bona fide required by the plaintiff. Now you are proposing that whether the suit comes under the purview of the Assam Non-Agricultural Tenancy Act
Yes.
of the agreement basis defaulter in payment of the house.
Specifically, the proposed issue number E, your lordship, it was declined by the court below. And another aspect.
Let us see the plain your written statement.
The statement is
What type of written statement we have enclosed out here?
annexure 4, your lordship.
Hmm.
Page 30 onwards.
Where have you taken the ground that you are owner of the land, leaseholder of the land?
Lordship, at page. The written statement starts from page 30, annexure 4, your lordship, and the relevant portion will start from para 11 at page 32. Your lordship. And I have also annexed the agreement specification. Here it is.
And in paragraph number 17, you have made that, na? It is pertinent to mention here that the plaintiff let out the vacant land premises to the defendant tenant and allowed him to construct permanent structures of the land, and the defendant already constructed the structures and here the truth comes within the purview of the Assam. Now this question have not been framed.
Another, there is an issue framed as regards to bona fide requirement, that was not a pleaded case of the case. There was no.
If it is not a pleaded
That-
case,
that
that
will
can
not
happen, but you want this question to be
this
framed.
question.
Yes, Mr. Sharma?
Whether they, in their written statement, they have stated that they have deposited the rent under the provision of the Assam Urban Resources Development.
Maybe, but then also when they have raised this issue, whether it is there or not, let the court, that is a question of proof. When their pleadings is there to that effect, what is wrong in framing that issue number E as an additional issue? It will be done. But Mr. PJ Mukherjee, the learned counsel appearing on behalf of the petitioner, Mr. A. Sharma, the learned senior counsel, assisted by Swen, appears on behalf of the respondent. The instant application under Article 227 of the Constitution has been filed, challenging the order dated 22/9/2022. Is it passed by the learned trial court? In Midze case number 37/22, arising out of title suit number 4/22. On the ground that the learned trial court failed to observe paragraph number 17 of the written statement, wherein it was the specific case of the defendant that the land, that it was the land, it was a vacant plot of land which was rented out to the, leased out to the petitioner oblique the defendant, and therefore had categorically stated, had categorically mentioned in the said paragraph that the case is covered under the provisions of the Assam Non-Agricultural Urban Area Tenancy Act 1955. Upon perusal of the written statement, more particularly at paragraph number 17, this court is of the opinion that the issue so suggested as inverted comma, whether the suit comes within the purview of the Assam Non-Agricultural Urban Area Tenancy Act 1955, question mark, can be framed as an additional issue to the issues already framed on 13/7/2022. Accordingly, this court therefore disposes of the instant writ petition with a direction upon the learned trial court to frame an additional issue in the said suit from the existing issues as framed on 13/7/2022. That is, whether the suit comes within the purview of the Assam Non-Agricultural Urban Area Tenancy Act 1955. Accordingly, the petition stands disposed with the above directions. It is further relevant to take note of that by the order dated 4/1/2023, this court had stayed the further proceedings of title suit number 4/2022, which was pending before the court of the Munsif Pirang Kajolgaon. In view of the above order and taking into account that the parties are duly represented, this court therefore directs the parties to appear before the learned trial court on 6/7/2023. And the trial court thereupon shall proceed with the adjudication by taking into account the directions passed herein in accordance with law.
Item 4.
If the notice has been served upon the respondent, nobody is appearing. What has also come.
Matter pertains to
Which shall ex parte he was passed. Ex parte he was passed
by
by the learned chief court member.
then
And I preferred the appeal. Appeal was also this ex parte he was passed during the COVID period. The 2020.
December 2020.
During the COVID. There was a notification also, no adverse or passed that period. Despite that, this ex parte was passed.
Here, why are you not able to serve it?
Service perhaps completed. Some office
Who are you?
I am the tenant.
Vimanandu Banerjee.
Yes. Earlier it was partnership, my lord.
Huh?
Earlier it was partnership, my lord. Then Mr. is a permanent
who
permanent,
are
he
these
expired,
people?
my lord. Then
You are
legal,
who?
I am the legal heir.
I.
The degree judgment. Three legal heirs are there.
Hmm?
Three legal heirs are there.
Who is the advocate? Nausad Alam.
So earlier he was there, my lord, but some Sharma. Before the appellate court, my lord, he appeared.
Who?
Mr. Sharma. S.K. Sharma.
Did you participate in the state proceeding?
Yes, earlier I participated, my lord. I filed the written statement also.
Then why you could not participate?
But during this COVID period, my lord, the advocates perhaps they did not appear.
When was the COVID period?
From 15/3, my lord,
To?
15/3 onwards, it was
15/3 to
2020
till?
till Honorable Supreme Court extended the period till
Are you going to say that all judgments which were passed in between are honest?
I am not saying that, my lord.
Only the limitation was extended.
Yes.
Did the Supreme Court say that all orders which will be passed will become non-est?
Restricted.
Was it
cases-
restricted when the matter was taken up?
Exactly, I don't know.
Then, well, how can you say all these things? It will have a serious consequence if we accept your submission. All judgments, all orders passed from 15/3 to 10/2 2022
Normally
will
this
become
is-
useless.
No, my lord.
Then
Normally, this
you
is
must have also got some arbitration awards also in the meantime. I'm going to say that the arbitration award should be thrown to the dustbin because it was passed during the period when the Supreme Court said that. Supreme Court never said. Only the period of limitation was extended. That is what I could understand. Then
during these periods of lockdown. there are also-
was there a lockdown at that period? When? Let us see. It was duly represented. S.K. Sharma was representing defendant.
At
Then
that point,
how can you
there was
say
no
it to be
lockdown.
exotic?
Yes, earlier we participated.
Are the arguments forwarded by the learned according to the learned so and so rebutted, no rebutted, no rebuttal of the evidence and claim of the plaintiff, and since it is apparent the defendant is a defaulter. Are you a defaulter or not?
Oh, my lord, as per my version in the retail statement, I have found it defaulter, my lord. And your lordship may kindly see the issue number 4.
Huh.
Whether the defendant has defaulted in payment of the rent in respect of the promises to the plaintiff. The
Whether the defendant has defaulted in payment of the rent in respect of the two premises to the plaintiff.
no specific date, no specific month is given, my lord. And the statement of the plaintiff says that the defendant is defaulter for the month of April 2010 and July. Only 2 specific period. Earlier he has made the statement there was some dispute about 466 square feet. That was settled
No,
down.
but Mr. Hussain, in whose burden does it lie? Whose burden it is to show?
Because if we take part-
Your burden. You are the thing. Then
Letter may be remanded, my lord.
why?
So chance may be given.
No, no, no. Court doesn't believe in all this remand business stuff. You know what is going to happen. Let us see how issue number 4 is decided. It is the case of the deceased defendant in his written statement as well as the additional written statement that on refusal of the acceptance of the rent by the plaintiff, he had deposited the rent in the court. An additional written say is apparent to the fact that defendant was aggrieved by the exorbitant enhanced rent at the statement regarding exorbitant enough. The defendant refused to pay the rent to the plaintiff directly. The remedy available for the defendant by filing a petition for parent was never exercised by the deceased defendant for his legal health, meaning thereby that the landlord's claim hence was refused. Furthermore, either to one and both supported the fact that the default on the part of the defendant and the evidence for rendered was never tested to cross-examination. Under the state backdrop of the case, the defendant failed to prove that he is not a defaulter. There is nothing to believe that the claim of the plaintiff that the defendant had defaulted in payment of the rent. The agreement of these basis was specific that the defendant was to pay for rupees 10 for 10,000 the tenant that the challenge made that they was a case made you did not tender any evidence.
Yes. My lord, your lordship may kindly see. This issue has been decided about the non-payment of the rent relating to 466 square feet. That was much earlier, beyond 3 years. And this is not.
No. Non-payment of the rent, he would not be entitled to get recovered. That is another.
Yes, yes.
But the default is a default.
Defaulter, my lord.
Where is the limitation for default?
When limitation for default of 3 years is there, my lord.
So you show me, you tell me, did you adduce any evidence?
No, my lord. Their evidence, it is their case, my lord.
No. It is not their case. They may only allege that you are a defaulter. It is you who is to show that you are not a defaulter. Let me see your written statement. What you have said.
Yes. Supplementary written statement.
Let's see the first written statement. Where is your written statement?
But my lord, I have this,
Huh?
my five brief, my lord, I have this. I am having some.
We will then see it from the record. Don't worry. Because
Written statement filed on 27
trial goes. A.
This was also, my lord, implicated decision for the part of the
Mr. Hussain,
My
the
lord.
record show that on 4/11/2019, relevant is this. It was much prior to even Corona affecting. And it was fixed on 4/1/2020 for cross-examination of PDP. On that day, on 6/2/2020, prior to Corona,
Yes, right.
you did not appear. Evidence was closed. Then it was fixed for defendant witness. And then, as the defendant was not there to say anything about it, the matter went ahead. And the defendant thereafter never appeared before. After many, many days, there was on 4/3/2020, 6/4/2020 was okay. These are lockdown. Then these are 2/2/20, 37/2020, 39/2050. These are all COVID. Then 9/11/2020 is represented so and so on behalf, peruse the case record, fixing for argument. Plaintiff is a hard argument of the learned counsel for the year, which argument is also submitted. That is on 5/89 and 5/12/2020. Judgment is ready and delivered. Plaintiff is petition. This is the state of affairs. Let us see your written statement. What it is.
Another point is there, my lord. No issue was framed regarding the bona fide record. Despite that, there is a right. Without framing this, my lord, how the points can be decided.
Let us see order 14 rule 5. What is it? Even at the time of writing the judgment, the court can.
Then, my lord, there should be an opportunity to the other side.
So the total house was, the rented premises was 10,466. Admittedly, you are saying that I have been all along paying you for 10,000.
Yes.
Where is the question now that I should pay for 466?
Now they settle matter. Both the parties settle. And the defendants also paid that for that portion. That is not an improvement.
That is there at paragraph 11 of your written statement.
Yes, it is
Then-
there, but
Then you by yourself categorically say that 466 I am not willing to pay.
yes, later on, both the parties settle that can be paid.
Where is it? That statement is not there. That there was an amicable
right.
settlement. You are saying out here that they were all along not asking that. Kindly see paragraph 11.
Paragraph 12, madam.
12 also. Where is it? There is a
Yes.
settlement.
In the last two lines of paragraph 12, madam. The claim for area rent is in any event not sustainable inasmuch as the answer defendant by way of a gesture of good paid rent for 466 per feet with effect from January 2007 till date, with effect from January 2000. And he accepted. Suit is, my lord, the plaintiff is saying that the defendants have not paid the rent for April 2010 and July 2000. And the defendant is saying that they have paid.
And we come to paragraph number 16.
That the defendant further state that the defendant, after having paid the rent for the month of April 2010 by way of check to register for rent,
How much was in your area?
10,466.
How much rent did you pay? Means the rent was paid on the basis of square feet.
Yes, correct.
Square feet.
Yes.
That was the agreement.
Yes,
So then, how much rent did you pay in the court?
the quote is there.
You paid as per 10,000 only.
No, letter of perhaps given. Galan, I have. It's 50,790.
Huh?
Galan is there.
Yes. Was it the earlier rent?
It is 1/5/2010. And thereafter, some dispute is there about increasement of the rent. That different.
And what is the rent now you are paying? At the rate of
Rate of one check is there, but amount is not.
6 rupees?
Perhaps there is no dispute about the amount of.
No, no, this is very early. 2003 it was 4. 2006 it was 6. 2008 they have made it 8. We are in 2023.
Some dispute is there. Then both the parties can approach the court for the answer.
You should have moved before and not to say that we are not going to pay. You can't say this. If there's an unreasonable demand, isn't it your duty to move applications for fair rent?
Yes.
Why did you do that?
Both parties can.
No, why both parties will move? It is your duty to move it. If he wants the enhancement, he can very well say so.
That would have
You have not done that. You have not given any evidence. Then now, where is the question of interference by the courts?
I know I pray for remanding matter so that opportunity may be given. Then you are put back.
I think you were very well taken care of for the
But
last
they
15
are
years.
not appearing, it means
I'm
they are
not concerned. And if somebody appears also, I wouldn't have asked him. I think,
waiting for
Mr.
hearing your
Hussain,
lordship.
you have already got all the benefits for
Because-
so many years.
What should be here? Because
What is there to hear? That is the most
Other
I
side is-
hear.
other side may come, my lord.
Huh?
Other side may come.
Not necessary. Well, what is there to hear the other side? I'm not going to hear the other side for that. You have not been able to make out your case. This is under 115.
Yes.
You have not given evidence. It's a case of defaulter and payment of rent. You have not given evidence. Matter ends there. And it is a clear-cut admission in paragraph number 11 and 16 that you have not paid for 466.
But that the city was
And
not
don't you
transferring.
think that you have already benefited a lot for all these years?
There is a rent. In the meantime, he enhanced the rent. The plaintiff also enhanced the rent.
And
It's
you are
not the
paying.
original rate that he is paying.
No, no. Did the plaintiff enhance them?
Yes, in the middle of this period,
When?
enhanced.
When did they
The
enhance?
written statement.
No, no, no. There is nothing on the written state. This was decreed then. During this period, when did he enhance?
After passing the decree,
Huh?
there is no enhancement.
No, no, prior to that,
Right there,
during the pendency, there was some legal notice issued.
yes, legal notice.
And what was that legal notice for?
That your lordship may kindly see the written statement, additional written statement, paragraph 18 about the payment. Additional written statement, paragraph 18
Of
about the payment of the rent.
no, your NJ case. I've looked into your NJ case 71 of 2010, where you have clearly admitted the fact.
It mentioned when the rent was 60,000 per month, the plaintiff paid the rent for the month of September 2007. So in 2007, it was 60,000. Now, as per the challan, the defendants paid 62,790. (2010). About enhancement is also there. Meantime, the rent were enhanced.
Now forget about enhancement, but we have not paid for 466.
Later on, we paid.
When?
I just read.
When did you pay for the 466? So it was not a lawful rent. You were given on the first floor 5,100 and 5,366 and down floor 5,100. You only paid for 5,000 or 10,000 only.
Later on, I paid for 466, my lord.
When did you pay?
And people,
Wait, your
Yes. just I made the statement earlier. I read,
Yes.
my lord. Paragraph 12, my lord, additional evidence. The claim for area rent is in any event not sustainable in as much as the answering defendant by way
Para?
of gesture of goodwill paid the rent for 466 square feet.
no, para
Para 12, my lord.
of
Of
the
additional written statement
additional written statement filed by
filed on 9/7/2013.
9/12/7/2013. Yes, paragraph
Paragraph 12, my lord.
that with regard to the government made in paragraph 5 and 6 of the amended bill,
At no point of time had ever claimed alleged rent for the purpose for purported 460 square feet of extra space in the premises either in the year 2003 or in earlier, when the late partner of the defendant, Shri R.K. Devra, had managed the warehouse, and the plaintiff in a most arbitrary manner had raised the issue of additional area rent for the said 466 square feet for the first time through the legal notice dated so and the answering defendant cannot be held liable to pay the same. Further, the defendant has never agreed to, at any point of time, to pay the plaintiff purported area rent against the said 466 square feet within the tenanted premises from the year 2003. And as such, the claim of the plaintiff being utterly false, frivolous, misconceived, and baseless, the defendant cannot be held liable to pay additional area rent from the year 2003, and the plaintiff is put to its strictest proof of it thereof. The claim for area rent is in any way not sustainable in as much as the answering defendant by way of gesture of goodwill paid rent for the 466 square feet with effect from January 2007 till date, with effect from January 2009.
what is this meaning? The last line?
It is
By way of a gesture of goodwill, paid rent
Yes.
for 466 square feet with effect from January 2000 till date. With effect from, what is this meaning? I don't understand.
this is not giving the effect.
No, it is much better when you are not clear.
I was not in the
No. Yes, Mr. Hussain.
My lord, in this plaint, my lord, lordship may kindly see, his claim is only rent for the month of, area rent for the month of April 2010. And what he says, my lord, the cause of action for this dispute arose on 1/4/2010, not beyond that. So cause of action relating to the facts which have arisen after 1/4/2010 is applicable here. This is his case, my. So regarding this payment, non-payment or delay payment or after payment of 466 square feet, my lord, is not the.
There was an amended plan
Yes, amended plan.
for which you have filed the amended written statement.
Yes. In amended plan, 1 month he has added. Not for the month of July 2010, which was paid by the check. Only for that purpose it was amended.
Hmm?
Only for that purpose it was amended. And another point, my lord, here this land is not in accordance with the provisions of CPC, my lord. No list of document has been mentioned. Only this is written like a read petition and is there, my. We have to follow strictly the CPC case of it. And in this respect, my lord, I am referring one judgment. The complaint is not in accordance with it.
Yes. No. You see paragraph 9A of the amended plan, and you have submitted a reply. Isn't this to be substantiated by evidence?
That I have not.
Then, okay. I've heard enough. And
My
not
lord,
pending
one
dispute.
judgment I am referring because this plaint is not in accordance with the law. No list of documents is filed with the plaint, my lord.
So,
So it is a defect, my lord. It should have been rejected. The plaint should be in accordance with the provisions of the CPC. No list of documents is there. He has annexed just like a writ petition or other petition.
so
This is not the mode of filing the plaint, my lord.
how does it become bad on that?
May not be on the judgment I am referring.
Where? Which court? To me. Let us also be knowledgeable on such judgment. That if a person encloses it as annexure, the plaint is to be rejected.
Not exactly on that, but regarding the CPC. Even your lordship may see the evidence is not in accordance with the provisions of the evidence.
So what is there?
About the following this,
So what else has it said that cannot be done? Didn't they claim the eviction of yours?
directly it is not only on CPC, my lord.
No. Isn't the suit filed for claiming eviction?
Yes.
On the ground of defaulter?
This case.
In your case?
Yes.
Then What about order 7, rule 7? Enough, Mr. You have been do one thing. Don't keep these type of matters as trivial.
Your lordship may reserve.
Hmm?
Your lordship may reserve it.
No, no. I'll do one thing. Let me finish up this order. This order. Here.
My lord, then
I delivered a judgment today.
my lord,
Ask your junior to be there.
yes, but I may be allowed because I have.
Yes. Ask it. I'll deliver it.
My lord, in this matter already I have communicated this to the SP. Only the thing is that that date was fixed for personal 29.
But Mr. Hart thought the learned counsel appeared, the learned petitioner senior government advocate. By an order dated 5/6/2023, this court had requested Mr. Hart thought the learned counsel to advise the superintendent of police to do the needful. And this court issued a fresh bailable warrant of arrest of rupees 10,000 against the respondent, thereby fixing the date of appearance of the respondent on 29th of June 2023. Today, Mr. Hart heard the learned counsel had mentioned the matter and submitted that 29th of June 2023 is a holiday of this court. And accordingly, this court should fix some other date. Taking into account the above, this court therefore fixes the matter again on 19th of July. The bailable warrant to issue warrant of arrest of 10,000 which was issued against the respondent, Sri Babulal Gogoi, is issued afresh, thereby fixing the date of appearance of the said respondent on 19th of July.
Should I tell my police to bring him on 19th? Yes. For appearance. I can do that. That will be.
How can you bring him if it's a valuable warrant?
Valuable warrant, but once he appears, here he has to give an undertaking to my officer in charge.
Yeah,
he'll be appearing on 19th.
And if he then does not, then it's a non-bailable.
We'll take an undertaking there.
The courtmaster of the court is directed to serve a true copy of the instant order to Mr. Arthur, the learned petitioner senior government advocate, for due advice to the superintendent of police, Withdrawal.
Item 45. Comply.
Complied. Huh?
Yes.
Heard Miss S. Purva,
Yes.
the learned counsel appearing on behalf of the applicant, and Mr.
I am for respondent.
You are the
Oh,
applicant,
yes.
and Mr. T. Bora appearing on behalf of the respondents. The instant application was filed by the applicant seeking extension of time for the reasons assigned in paragraph number 2 of the state application. It has been brought to the attention of this court by Ms. S. Purva that the judgment in order dated 16/12/2022 passed in WPC number 1947/2022 has already been complied with by an order dated 26/5/2023. In that regard, the order dated 26/5/2023 has been placed on record, which kept it has been submitted during the course of the hearing. It is kept on record and marked with the letter S. In that view of the matter, the instant application has become insufficient. Consent to
Obliged.
Item number 46, stay with us.
yes. What do you want here?
Praying for transfer of the present proceeding from the Court of Honorable Additional District Judge Dibrugarh to the Court of Honorable Principal Judge Mohan Kamru Metro.
Why?
Because your Lordship, the petitioner is a lady present.
So,
So the hardship which I have presented before your Lordship is that
what matter is this?
Your Lordship,
The criminal proceeding.
no, your Lordship, divorce proceeding.
Why is the divorce proceeding before the chief judicial magistrate? No.
No, your Lordship, earlier there was a proceeding of 145.
Where's the
That-
plain?
That proceeding was for the learned chief judicial.
Where is the
Presently, the
plain?
divorce proceeding, your Lordship, the divorce application is at page 48 annexure 5.
You have filed your written statement.
No, your Lordship.
Right.
On the very first day, when we received the notice, we approached the post office.
And it has been pending since then.
Yes, your Lordship.
And
the
what has happened about service?
Service, your Lordship, the notice was issued, but till date the AD card has not been returned. The office note shows that even the usual process it was sent, but no report has come. Your Lordship, I can take again, I can take step for the respondent.
Taking steps in this manner. You are residing here at
At Kalapahar, your Lordship.
why? Your father's house is there?
Yes, your
Or
Lordship.
what are you doing here?
Because your Lordship, the respondent concerned had failed to pay the maintenance, does not maintain me. I was left all alone. So during COVID times, I had to come along with my father. And moreover, the allegation as made in the divorce application was with regard to I am having an illicit relationship with the cousin brother of the respondent. So the villagers, what they did, they also burned away all my clothes and belongings. So such was the circumstances. I had no option but to leave the matrimony.
Heard Mr. A.K. Wright, the learned counsel appearing on behalf of the applicant. It appears in the records of service that it appears that although notice was issued on 29/2021, but the service upon the respondent is yet to be completed. And in the meantime, the proceeding before the court of the additional district judge Dibrugarh has been stayed. Taking into account the above, this court directs the petitioner to take steps by way of justice rooted to the registry of the court and file an affidavit of service on or before the next day.
Your Lordship, justice is not possible because the respondent
Then
person
I'll
is in
dismiss it.
Jammu and Kashmir. Jammu and Kashmir. He is presently posted in Jammu and Kashmir.
Then why you are putting his address now?
His
at Guwahati?
permanent address as shown in the divorce application.
No, you know that he is in Jammu and Kashmir. Then why have you put the address here?
Your Lordship, why I am submitting this? If Your Lordship comes to the
No, you then have to amend it. You can't make this thing. You are putting this address. You are going to again. You have made a submission now that you are again going to take the address in the same thing.
no, Your Lordship,
Then
if Your Lordship permit me, page 49 of the divorce application.
yes,
Here in para 1, here stated that presently posted at 150 General Hospital, Rajauri, Jammu Kashmir. Permit me to take steps in the concerned action. If Your Lordship permit me, I will take steps on the concerned action.
yeah, you take it.
Because I took it, because in the divorce application, if Your Lordship page 48, he has given his permanent address. Upon that address only, I have to be taking steps. But for the ends of justice, since he is stating that it's in Jammu and Kashmir, allow me to take steps.
Justice.
Your Lordship, Jammu and
So take it if you want us to hear. The court is like 2 years have already passed by. Does it look nice for a transfer matter to be pending? Make a paper publication
yes, that I can.
at Jammu and Kashmir. Not here. You can't make a paper with the publication as you say now that it is in Jammu and Kashmir.
At this, let me first try and make an endeavor to send it by register post to Jammu and Kashmir. First endeavor, let me, if it does not come anything from Jammu and Kashmir, then we'll make an endeavor to make a publication, paper publication. So that will be a substituted service, paper publication. Let me make a direct service to Jammu and Kashmir by way of register. First.
Clear. Yes. नहीं तार आगोर लाइन को लेके service has not and the proceedings have already. Be that as it may, Mr. A.K. Roy, the learned counsel appearing on behalf of the petitioner, submit that to the knowledge of the petitioner, the respondent is presently posted at 150 General Hospital, Rajouri, Jammu and Kashmir. Under such circumstances, he submits that he may be permitted to take fresh steps upon the respondent at the said address. This court therefore directs the petitioner to take fresh steps upon the respondent at the address at his address upon the respondent at his address at 150 General Hospital, Rajouri, Jammu and Kashmir, by registered as well as usual within 3 days. List the matter again on 28th of July. Don't require, he is not there. Why do you need an inquiry? He will automatically come.
Since it is not
Service will automatically get completed. Don't worry.
Your Lordship, that I will take, but the interim order,
Could I reject it? The prayer.
since your Lordship, at least the interim order was passed. The further
Sorry.
proceeding was stayed.
Sorry, I'm not going. The reason I'm not granting it now, the service will be complete. You know nothing is going to happen.
But I have been taking steps, Your Lordship.
Because if you want, I can put that observation that this court is not in. But you want that. Do not.
47.
I'm for the respondent.
Where is
I
the,
have submitted my affidavit in opposition.
where is the petitioner? Who is appearing? Where is the petitioner? What does the petitioner want?
Petitioner wants to transfer the matrimonial proceeding from District Judge Golaghat to the learned additional District Judge Margate.
Why?
My lord, my lord, if your lordship come to page 3, paragraph 3, their main difficulty from coming to Margherita to Golaghat is my lord, paragraph 2, that the petitioner is a homemaker and has been residing at her maternal home situated at above mentioned locality along with her ailing mother, elder brother and his family since 21/8/2022. The day when the petitioner went to visit her maternal home normally. Malad, say Malad, she is having an ailing mother, but Malad, she is having also an elder brother and his family is there at the Margherita. And Malad, they are mainly seeking transfer by saying that in page 5, paragraph 6, last paragraph, thus in such a situation, if the petitioner is required to be present before the district court Golaghat, then the petitioner who is an unemployed lady will have to depend on her brother for the expenses that she will have to incur for her traveling, and the petitioner who is not an independent lady will again have to depend on her brother. They are mainly, and thus the expenses of traveling would become twice, and in a condition where the petitioner does not have a single penny to herself, she would take her brother's family along with herself towards other.
Pay 3,000 on her every visit to the court.
My lord,
Pay 3,000 on her every visit to the court. You're opposing.
my lord, on the required date, my lord, on the requisite date.
None appears on behalf of the petitioner. Mr.
M. Doctor.
M. Datta appears on behalf of the respondent. The instant application has been filed under section 24. Section 24 of the Code of Civil Procedure 1908 for transfer of the matrimonial suit number 20 of 2022 pending before the court of the District Judge Golaghat to the court of the additional District Judge Margaret. Madam, you are appearing. You are not transferring it. He will pay you 3,000 rupees every time when you visit.
But I have to be accompanied by my brother because I'm not a person who can travel everywhere.
Madam, first and foremost, in these courts, these are not family courts. You can very well appear to the lawyer. Then you were getting 3,000. Now with your appearance, that 3,000 is gone. I'm dismissing on that ground.
I did not, but I'm
You don't need me need to appear. You have a lawyer. Lawyer will appear. In Golaghat also, you have to have a lawyer. And in there also, you have to have a lawyer. Now, every time you appear, you get 3,000.
The lawyer, the person has to travel. Even to appoint a lawyer, the person has to travel.
So there, you are getting 3,000 for that.
Doctor, at that point, I'll have
No, 3,000 per appearance is too good. And what do you do?
But I will pay the
Businessman.
3,000 on the requisite day, my lord.
What is your business?
My lord, I am a school teacher working in a private school, my lord.
Private.
I have annexed my income certificate, my lord.
How
I am
much do
getting
you earn?
4,000, my lord.
Huh?
I am getting only 4,000. My lord, annexed.
4,000 only.
4,000 per month, my lord. And
Minimum wages is much more than that.
that is true, my lord. I have, my lord, submitted my certificate, my lord.
So then also giving 3,000.
And the difficulty is also there, my lord, because my
Also, he can also travel to that. Lot of a lot of decisions the Supreme Court has always said that it is the issue has to be decided. And a lot of decisions that Supreme Court it has
There are many decisions which are against you.
yes, but lots of the
Why do you spend 3,000? You go there.
my lord, my difficulty is that, my lord, I am having, my lord, my mother, aged about 80 years, and my younger brother. Both are bedridden, my lord. That's the
lots of
difficulty, my
contention that is younger
And I
brother
have,
is
my lord,
bedridden is not correct because the document that he has submitted says that he probably undergone gallbladder surgery in the year 2022 in July, and by 2023 a person recovered, and he has a better possibility of traveling that.
It's an application under section 24 of the Code of Civil Procedure for transfer of the matrimonial suit number 20 of 2022 from the court of the learned district judge Golaghat to the court of the learned additional district judge Margaret. Why it should be transferred to Margaret?
Sort of the place where I stay.
Why not in next to your home? You should have a court out. On perusal of the materials and taking into account more particularly the statements made in paragraph number 6 wherein the basic ground alleged is that the petitioner herein does not have the money to travel to Golaghat on each and every day for appearance before the court. It appears to the court that it on account of it appears to the court that it is on account of that the petition it is only a homemaker and not in a position to travel to Golaghat and incur the expenses thereof. The instant petition has been filed. On the other hand, a perusal of the district statement affidavit is opposition filed by the respondent shows that the respondent has an ailing mother and a brother who the respondent has to take care of. It is also relevant to take note of that in the proceedings before the district judge at Golaghat, the provisions of section 13 of the Family Codes Act 1984 do not apply. And as such, the petitioner can very well appear before the state court through a counsel. except on such date as the trial court may direct the petitioner to appear, or on such date when the petitioner has to appear on account of tendering evidence. Or submission of evidence, tendering evidence, or appearing for cross-examination. This court is of the view that the interest of justice would be met if a direction is given to the respondent to pay an amount of rupees 3,000 on the dates on which the petitioner has to appear before the trial court. Accordingly, this court disposes of the instant application for transfer. Now, according, this court is not inclined to transfer the matrimonial suit number 20 of 2022 pending before the court of the district judge Golaghat to the court of the additional district judge Margaret. However, this court directs the respondent to pay an amount of rupees 3,000 on such date on which the petitioner has to appear before the trial. Interim order past tense vacated. Did you file your written statement? Tense vacated, and the parties are directed to appear before the trial court, before the court of the district judge Golaghat on 26th of July 2023. On which date the petitioner shall file her written statement without fail. 48.
For transferring the status of matrimonial from Vishnu Sarili to Nalbari. Okay, well, that's self-study. I've got a affidavit filed by the respondent. This is not in record.
Not necessary. I don't also look into it. You tell me. Why do you want?
Next, it is both are original from Nalbari.
Then?
And now the respondent is Vishnu Sarili.
Who?
Respondent husband. Even Vishnu Sarili. And on the
then why you are not filing it at Nalbari? You are presently, you say that what is your address? Presently residing at somebody's house?
no, Lordship.
Is your house over there?
No, Lordship.
What are you doing there? Where's the plane?
I'm a service level Lordship and
You are
appointed a pharmacist in the Calgary PH.
where is the application for plane? Where is it? That one, Mr. Parakar.
My lord.
Where is the suit?
Only I have not received only the enacting the receipt notice page 11
Then
page 11
page 11 is what?
only the notice received from the course of
What are you doing?
I'm a pharmacist in the Calgary PH.
Hello, good.
Then it is a healthcare services emergency service activity. So I'll pay. Take difficult.
Nalbari to Vishwanath Sarili. How will she go?
And Lordship, I have one minor school going children also.
Minor?
Minor school going son also. Lordship.
Installment.
School going son.
Oh. You are in possession of the, you are in custody of the son?
Yes, Lordship. She has neglected to look after my son, Lordship. and he is studying here there. There's no one to look after him if I had to come to Nalbari Lordship. That is my difficulty.
And why you can't go there?
Malad, he actually on January Malad, they kept me in my house, Malad, and second like the son Malad and went to Malad.
Understood. But why you can't go to the? Why can't you go? No, Mr. Parasa,
I
kindly.
along Malad cannot go Malad with any support. I along cannot go with any support Malad. My brother is in particular year of Malad.
Have you got a copy of the claim?
Planes only I received the Malad that notice copy.
Where's the copy of the claim? You have it?
I have it.
Make a photocopy, give it to him. It's for same time. Whenever he goes 3,000, you pay.
Malad kindly Malad. If Malad allow me Malad any one date Malad. Today Malad morning I've got the.
No. These affidavits I don't know. This is a question of transfer. First of all, Mr. Parasa, these are not courts where you have to appear. You have to engage a counsel. I would only understand in respect to family court. Once the family court comes in, then the thing becomes different. Let us have a family court somewhere. Well, you are the central government council. Why don't you ask these people to have family courts and then come up with a petition of this type? We will very well be accommodating you. You go, pay 3,000 whenever she goes. Same 28/7, file your written statement. You give a copy to of the claim.
49.
Lordship, in this case, Lordship, I am seeking transfer from the court of family court in Dimapur to the district judge Bulara. The petitioner, my lord, she is an unemployed dependent lady and having a minor student, my lord, minor son, and he is presently studying at Golaghat at Gopalpur, Ballabhogan, my lord. I have annexed the
Recently, the division, the Supreme Court had given out a decision that the High Court can decide this estate.
Yes. Our High Court has also.
No. Because this will be a transfer from Nagaland to Guwahati to Assam.
Yes, my lord. Their division bench judgment because Kohima is a outlying bench. So that's why it can be entertained by this.
Yeah, na?
Yes.
Yes, then
Then, my lord, two, my lord, case, my lord, between the same party, two case has already been pending at Golaghat.
transfer.
My lord,
When you have filed your written statement?
No.
File the written statement on 28, transfer to Golaghat. You wanted the Golaghat?
Yes.
my lord, but I am ready to pay the cost.
No. This is family. Family court he has to appear.
My lord, I have a small prayer, my lord. My lord, because my lord, the petitioner he is having,
Dimapur, Mr.
no, my lord,
Mr.
I
Bora,
am not-
kindly see Dimapur to Golaghat is very near.
I am not praying for Dimapur, my lord. I am praying that it may be held somewhere else, either in Jorhat, my lord. Because, my lord, that there is state perception of the respondent, my lord. So I pray that the case may be transferred to a nearer place, Jorhat, my lord, not Golaghat, my lord. Because in these two cases, my lord, he has appeared and he has faced lot of difficulties, my lord.
But there are two factors of there you don't need to appear every time.
Yes, my lord.
Golaghat is the district court.
Jorhat also, my lord. I am ready to pay the
She
cost.
has to again go. Why you are troubling that?
No, my lord. In Jorhat district judge court, my lord.
But she has to go from Golaghat to Jorhat. Again, unnecessary you have to pay.
Yes, my lord.
Problem.
50. Yes, Mr. Bora.
From Udalguri to Sarai to
Dalguri to Sarai. How far?
331 kilos. Now I have 4-year-old son. There also my kid. The marriage was solemnized in Sitagar. And
Marriage was solemnized at Sagar.
Sitagar.
And
and the defendant is cited itself.
You are staying in
Soraido.
Soraido. Now it becomes Soraido. Earlier it was Siptagar, now it's
Siptagar.
Soraido. Defendant resides. So
Now
let us see the claim.
Yes, page 18.
Hmm? You try to, when have you started living here? You were residing there? Last, both of you stayed where?
Last, initially I got to Udalguri, but I stayed for there only for 9 days. I had to come back
Why?
because of we had some altercation. We came back to my matrimonial house. Since then, I've been staying there. Now in Paraido, there is a maintenance case also is pending, where he is appearing.
You have mentioned the details.
Yes, yes.
That's why.
Lordship, yes, she herself, own conscience, she has gone to her parents' house. Even Soraido, the maintenance case is already disposed, Lordship. I have all as a parent, Lordship. I am only one son, Lordship.
So you don't have to appear every day. Here the marriage was solemnized at Siptagar.
The case is at Udalguri initial stage, Lordship.
So they will go and file it within statement. Why don't you go and help it out? So it is not a case for not allowing the transfer. Transfer allows you file your written statement on 26th of July. You have not filed your written statement? Okay. File your written statement. Transfer to because right.
Sorry.
Item number 8 for the eight.
None appears on behalf of the appellant for court. It appears from the office note dated 9/6/2023 that the postal endorsement with respect to the respondent number 5 is that the addressee had expired. This is the matter after 2 months.
Nine.
We have taken steps
Upon response number 2A. Your name?
SK Chakro.
Mr. SK Chakraborty, the learned counsel for the appellant, that today steps have been taken against the steps have been taken up the duties of the this is the matter of the service.
10.
None appears. You are appearing, Mr. Das?
Or respondent. Or respondent.
Respond number 8 also.
Item 10.
10. Respond number 10 also. Yes, you are not appearing for respondent number 8.
No.
We are appearing for respondent number 1 to 7. None appears on behalf of the appellant on cause. It further transpires from the order of the Lozima Court dated 25/1/2021 that the appellant has failed to take steps upon the respondent number 8. LCR has also been received in the meantime. That the matter be listed immediately after the summer vacations on 21st of July 2023 for orders. It is made clear if the appellant fails to take steps upon the respondent number 8, this court shall have no other option but to proceed with the matter thereby deleting the respondent number, the name of the respondent number 8 at the risk of the appellant. Mr. D.K. Das appears on behalf of the respondent number 1 to 7.
11.
Yes.
The lawsuit is taken the step, but it is service is in return as answer. Steps have been taken. Service notice, I think it is
Service is awaited.
awaited.
Your name?
PTAP. PTAP.
Or Mr. P. Day, the learned counsel appearing on behalf of the applicant, submits that the steps have been taken and the service is awaited. List the matter again after completion of the service.
12.
Await service.
Yes, sir.
13.
Appearing for all the response.
Even the dead one? Service report on respondent number 3 have been received back along with concerning service process server report that the notice could not be served as the respondent died on 27/9/2018. It is RFA, na?
Yes, sir.
109.
108 of 2009.
108 or 109?
108.
108 ne 108. 108. Saturday. They're paying for Saturday also.
Yes, sir.
You have filed wakalatnama, madam. You have not appeared for 3. Your wakalatnama says about 1, 2, 4, 5, 6, and 7.
In my file, it's written all respondents may be. It's a mistake in the office lot.
Correct it. You are appearing for a post. None appears on behalf of the appellant on cause. Ms. S2D appears on behalf of the respondent number 1, 2, 4, 5, 6, and 7. It appears from the office note dated 9/6/2023 that the service could not be affected upon the respondent number 3 as The response state responded had expired on 27/9/2018. So, taking into account, let the matter be listed after 3 months.
Apply, sir.
3 months is the time, na? 90 days. Otherwise, abatement.
Yes.
14,
Please, Your Lord. There is the office note of 1923.
Hmm.
By which I thought transfer the matter. Notice of the court.
What is this matter about?
No, this is the
LC record of TC has been received from civil judge number 2 consisting of 4 files. AD card as well as service report on behalf of respondent has not been received in the concerned section. Unserved notice on receipt has been returned back addressee out of state. Service report on behalf of the respondent number has received along with the concerning server stating that notice could not be served due to lockdown caused by COVID. What? How can there be a COVID? COVID, this RFA is filed in 2023, there is no COVID. Could not be served due to lockdown caused by COVID. Yes. Let's see. This notice could not be. Oh, it's RFA number 2019.
19.
This one. Then what to do?
I can take this.
The Mr. N. Alam appears on behalf of the appellant. It appears from the office note that the service has not been complete as against the respondent numbers 1, 2, and 3.
Well, P has been defected.
Huh?
P has been defected.
Affected?
Defected.
How?
Service note dated 9623 reflect.
Has been received of the due process upon respond number 1 and 2. Taking into account the same, the appellant is directed to take fresh steps on the respondent numbers 1 and 2 by way of register as usual. Where are these people residing?
Follow up 41.
And why don't you take justice? Take it.
So we are not having good relationship, so they will not keep any.
Huh?
We are not having cordial relationship.
You have?
Not having cordial relationship.
Not necessary.
They will not keep.
Anybody can go and if he doesn't receive, you file an affidavit. That person doesn't go have to go. You can send your clerk and get that. This is 1A. Where is 3? RFA. Where is 3? There's no 3 here. No?
1A,
1A, 1C.
1.
And 2.
2.
Where is 3?
My memo, they don't number 3. But they have
I
realized
also don't have. In my memo profile also there is no.
No number 3, madam.
No. 1A and 1C.
1B. But the numbers are 3 total.
That is the material, but has to be done in this manner, and the principal defendants have not been done. Okay, heard Mr. N. Alam, the learned counsel appearing on behalf of the appellant. It appears on record that the service has been completed against the respondent number 2. Ranjana Bora, it has been done. However, as regards the performer respondent number 2, however, as regards the respondent numbers 1A and 1C, where is 1B? No 1B.
No 1B.
Difficult type of appeal. The service is not, however, not complete. The learning counsel for the appellant submits that he would take fresh steps upon the state respondent. The appellant is directed to take steps by way of registered as well as usual within 3 days. This court further fixes the matter on 28th of July 2023. In the meantime, the appellant is further directed to take steps by way of trustee routed to the registry of the court and file an affidavit of service.
Fifteen.
Yeah. None appeals on behalf of the appellant petitioner on call. It further appears from the order of the Lodgement Court dated 6/6/2023 that the petitioner did not appear therein also. Further to that, it also reveals that in spite of various directions, the petitioner have not taken steps upon the respondent. Taking into account, it seems that the petitioner is not interested in the state proceedings, for which the instant petition stands dismissed for non-prosecution. The interim order dated 18/9/2019 stands vacated. The registry is directed to apprise the court below about the instant order.
16.
The await service report. Await service.
Yes, madam. 4 and 5.
4 and
4. Other,
you are appearing for
1, 2, 3, and 6.
and
6.
What about 4 and 5? You don't know them. Okay.
Oh, same family.
Same family.
But I do not have any instruction.
17.
What is the relation between 4 and 5 with respondent number 6?
But I do not know, my lord.
With 1, 2, and 3, you don't know.
Right now, I do not have file, my lord. I got the wrong file.
What is the relation, Mr. Thakur?
madam. Initiative file of Satyendranath was their father.
Huh?
Satyendranath was their father. And from Satyendranath, Satyendranath and Jumunnath was the nephew, my lord. Lead that.
4 and 5. Okay.
Okay,
You the office note dated 5/6/2023 shows that the service upon the respondent number 4 and 5 is not yet is awaited. Accordingly, list the matter again on 26th of July 2023, whereupon the office is registry is directed to update the service as regards the respondent number 4 and 5.
all right.
All right.
17.
Are they take this this and in IA we take the
You have taken? Why?
IA got we are taking
Appellants were directed to take steps for service of notice upon the respondent by usual process, as well as by registered AD. However, no such steps have been received.
are it
Stay is there. We vacate the stay. Then, when are you taking steps? The learned counsel appearing on behalf of the appellant submits that that the appellant shall take steps by tomorrow. List the matter again on 24th of July 2023 with an update as regards the steps being taken.
18,
LCR not received. You are appearing for?
1 and 2 respondents.
And how many respondents are?
3.
What about 3?
As per my lord, they are appearing for
Huh? Who is 3?
I'm appearing for respondent number 1 and 3.
1 and
One and
what about 2?
2 has died here.
Two.
My lord.
You have taken steps? Not necessary.
There are only my lord, one is the my lord, two was the mother and three of the daughter.
Okay.
Mother has died also.
Heard Mr. J.C. Court, the learned counsel appearing on behalf of the appellant and
See me. See me.
so and so appears on behalf of the respondent number 1 and 3. It has been informed to this court that respondent number 2 had prior to the learned counsel for the appellant submits that as the son, as the respondent number 1 is the son of the respondent number 2, her estate is duly represented. It further appears that the LCR have not yet been received. The registry is directed to forthwith issue necessary requisition for getting the LCR. To list the matter for hearing immediately upon receipt of the LCR.
20,
You have heard?
One respondent number 1,
How many respondents?
2 respondent services awaited on respondent number 2.
You are paying for 2? He is also 1. Vote 1. Why didn't you divide it and have another one for 2?
I don't know, but we have, I have just checked the-
Huh?
I would discuss with
I don't know. One of my colleague has just engaged me. I don't know. I checked the Wakalat number also.
And you appeared without taking the no objection.
No.
He is appearing.
Then I withdraw it. I am sorry, but I just I didn't know that he's there.
Okay. Anyway, I think sort it out outside. And has the records or LCR of WCEC number so and so consisting of one file has been received from the commissioner. Wakalatnama on behalf of respondent has been received and the same is kept on a AED card as regards service on the respondent number 2 has not been received. Who is number 2? That is the problem. We have to wait or you are going to take first step?
Sir, I was the file I
Or
what
huh?
what is that the
I is there.
but there is no tag.
There's not up. Anyway, it appears from the office note dated 6/6/2023 that the service upon the respondent number 2 is not complete. Taking into account the same, let the matter be listed after 4 weeks and the registry after 4 weeks on will be listed again on 7th of August 2023, on which date the registry shall update on the status of the service upon the respondent number 2. Mr.
Yes.
When appearing on behalf of the respondent number 1 submits that the respondent number 1 had filed an application for release of the amount deposited by the appellant. The registry shall duly take note of the same and list the matter as on such date as may be deemed fit.
But Lordship, I'm very sorry, I didn't know actually.
Okay, sort it out.
My name was showing and there was the Vakalanam. I just did the Vakalanam.
ठीक है ना? हाँ. Now which how? Chapter 21.
Made with this a lot. But the respondent had expired notice of time may be granted by the applicant.
When did the respondent expire?
I'm not aware about the exact date, but in this case,
This was given on 1/2/2023. I can't grant you time.
it's big practice. We were not informed. Lordship.
No. The order is there on 1/2/2023. There's an order passed by this court that the respondent had expired. Sole respondent had expired. Then why haven't you done anything? No application has been filed. So it is abated. You don't take steps, it is gone. It reveals. Heard your name?
Miss P. Devi, Lord, on behalf of
Miss-
Mr. SP.
Huh?
Miss P. Devi on behalf of Mr. SP.
SP Chaudhary. SP Chaudhary is not here. Look, heard Miss PDB, the learned counsel appearing on behalf of the appellant. It appears from the office note dated 4/1/2023 that there is a postal endorsement that the addressee had expired. It further appears that on 1/2/2023, this court had granted 3 weeks' time to the appellant to take appropriate steps for substitution of the legal representatives of the sole respondent. However, as no steps have been taken, the instant appeal abates.
Obliged.
"22. Wait and stand. Yes, Mr. Dick.
That your Lordship would be pleased to.
Whatever respond number 7.
Turn to page 46.
Hmm?
Turn to page 46.
8.
So, my lord, that respondent, pro forma respondent number 7,
Is
Eliza.
a performer respondent
Yes, my lord.
in
Eliza
appeal?
Khatun, died on 25/5/2018 at the lower court stage. But we in a
Who
mistaken
died? Who
way.
died?
Eliza Khatun, case 46.
Is a performer respondent.
Yes.
So nothing, not necessary. Heard Mr. M.H. the learned counsel appearing on behalf of the appellant. You are appearing for?
Lordship, 1A, 1B, 1C, 1D, 2 and 3.
And for your name?
And Hope.
Appears on behalf of respondent number 1A, 1B, 1C, 1D, 2 and 3. It appears from the records that the respondent number 7, performer respondent number 7 had expired.
Page 46.
Page
46.
No, page 46 here. Here everything finishes by page 29. Page 46. It further appears that the said respondent was also a performer defendant in the original suit. And she didn't file a written statement. And as submitted, the said performer respondent number 7 had also not filed any written statement. Taking into account the above, this court is of the opinion that there is no requirement for substitution as regards the performer respondent number 7. As the service is otherwise complete, list the matter of the hearing. LCR has been received in its usual course.
23.
Appeal, Your Lord.
Delay.
I am withdrawing this appeal.
Huh? You're withdrawing?
Matter has been settled after the court, my lord, between the parties.
Heard Mr. N. Alam, the learned counsel, appearing on behalf of the applicant. IA Tibode, IAC number 439/2002. Who submits that the matter have been settled out of court between the parties. And accordingly, he does not want to press the instant application seeking condonation of the delay in filing the accompanying regular first appeal. In that view of the matter, the instant application stands closed on withdrawal. The accompanying appeal bearing filing number
15316, ma'am.
number 2. Bearing filing number 15316/19 also stands closed in view of the withdrawal of the condonation.
24.
Yes, what is this?
For the last order of opposite report that
IA for what?
Injection, my lord.
And you are paying for everybody?
My lord.
You are paying for all?
My lord.
What is this injunction you are paying for? There is some order passed.
My lord, status order also. For the moment,
was not for lot.
You mentioned that the two properties, the plot of land is very expensive. And
there is an order, my lord, 10/123, calling for a report from the police of better PS.
who is appearing for the government? Oh, that matter. Remember, I passed some order.
My lord, on 18/123, my lord.
Because of the violation of the period. So you are not carrying out any
My
construction.
lord, with all respect, not getting out any cost.
Yes, the
And my lord, I am
construction is being carried on.
Huh?
The construction is being carried on. We have asked our but the
Very
thing that it is carried on, and we have filed an additional affidavit also on 8/2/22 lordship. Thereafter, an order was passed on 22nd February for police report, but we have received
as far as my lord, my instructions are concerned, my lord, no construction is being carried out, my lord. In defiance of the order of status of this report.
Madam, we do one thing. We close this IA saying that making it absolute till the disposal of the suit.
My lord.
If there is any violation, you file in contempt or whatever may be.
My lord.
Isn't it?
My lord.
But Ms. Espodi, the learned counsel appearing on behalf of the applicant, Mr. N. Alam appears on behalf of the opposite party. This court, by an order dated 1/9/2020, after taking into account the various aspects of the matter, have directed that the parties not to carry out any construction over the two plan, as it would may result in change in the nature of two plan as on today. Change in the nature of the two. The learned counsel appearing on behalf of the respondent opposite party, Mr. N. Alam, submit that they have not carried out any construction, and they are also not to carry out any construction during the pendency of the incident. Taking into account the above, this court therefore disposes of the incident application, taking injunction by directing both the parties not to raise any form of not to carry out any form of construction over the two plan, as described in the plain. You are the plaintiff.
I'm defendant.
Schedule A, Lord.
Huh?
Schedule A.
Not to carry out any construction over what?
Schedule A3, my lord. Their claim is in respect of Schedule A3 out of Schedule A. You lordship can to page 56.
Where is your application?
It has been annexed by the with a
No,
memo.
not the plain. Where is your application for? What is the application? In respect to the two plan. Two plan is what two plan?
A3, my lord. Schedule A3.
A is the part of our is the part of A, schedule A land which belongs.
I'm not concerned with that. You have not specified what is the two plan. Where is the plane? When you do civil matters, you have to be more specific, madam. You can't be to that effect. Understandable, if it is in a pension matter, you don't give many things, but here you have to be clear. Just put that. A3. Declare to be passed a training the defendant to enter into Schedule A3. Schedule land within A and thereby creating any obstruction, discrepancy. So it is only A3.
A3, my lord, out of Schedule A.
That is the Schedule A3 land as described in the claim. Till the disposal of the connected regular safety and appeal. I accordingly stands disposed. And the RSA records have been received. No? It RSA to be heard Ms. Estodi, the learned counsel appearing on behalf of the appellant, and Mr. N. Alam appearing on behalf of the respondents. Taking into account that the LCR has been duly received, list the matter for hearing in its usual course.
25.
And another thing of this, we had find one amended data consultant, but amended data consultant. I have put data consultant. That I have not found it direct. Because file on 98.
So you have issued notice on which one?
The amended one. Amended.
That has not come. Then how can a notice be issued if it is on the amended one and the amended one is not connected to the record? Let's keep it service not await service.
26.
Yes, Mr. Chakraborty, you have not taken steps.
My lord, we could not collect the proper address. My lord, therefore I pray we may be allowed to make paper copy.
You have to file an I. But Mr. S.K. Chakraborty, the learned counsel appearing on behalf of the appellant, to submit that as the appellant, I have not been able to collect the proper address of the respondent. He may be permitted to take effect service by way of substituted mode. This court is of the opinion that if such request is to be made, the same has to be by way of an application. The learned counsel for the appellant submits that he shall file the application within 2 weeks from today. List the matter immediately after filing of the state application.
27.
How many respondents are there?
14.
You are appearing from 1 to 8.
1 to 8.
What about 9 to 14? They are performer.
Performer.
You want them to, you want to proceed with them? The steps have not been complete. You have not given steps also as regards the respondent number 5, 9 to 14. Why? Why? Cost. Yesterday only your bar association president said we have to impose cost upon you so that it goes to your benevolent fund. Why not? The cost of 10,000 seems to be reasonable. This is a 2021 matter. Why haven't you taken steps? Tell me. Mr. Manso, Alam.
I on behalf of HRH. I on behalf of HRH.
HRA Chaudhary.
On behalf of
Get him. You want him?
I am Alamgir. I am not with the
So you can't give an undertaking that you are going to take steps. Can you give an undertaking or not?
but I will take
Mr. HRA Chaudhary, is he a senior advocate?
the airport.
Does he take, is he in the business of taking steps? Then, heard Mr. M. Alok, the learned counsel appearing on behalf of the appellant, who submits that steps upon the respondent numbers 9 to 14 shall be taken within a period of 1 week from today. Mr.
M. Hussain.
M. Hussain appears for the respondent number 1 to 8. It further appears from the office note dated 25/5/2023 that the LCR has not been received. Taking into account the above, the registry is also directed to take steps for requisition of the LCR at the earliest.
Most of it.
28,
Is your logic that is it by 2,664?
The filing objection?
Yes, they have already filed. They have already they have taken the cost for adjournment.
Huh?
They have taken the cost for adjournment.
Gentlemen, the learned counsel for the respondent seeks for an accommodation. Accordingly, list the matter immediately after the sum of the case.
29,
Yes, Mr. Sheikh, you are not appearing.
Steps on respondent number 2 to 34.
You are not taking.
But I have not taken, my lord, on the belief that they have filed a KPA and by
My lord,
respondent
on behalf
number
of
1.
one only. But
So,
today
sir,
morning I have
we
talked
are-
with my clients
We are
that
in the
subsequently
belief.
they will furnish Ukalatnama.
You will be appearing. You will be
Yes,
appearing
yes,
for
ma'am.
2 to 34.
Yes, ma'am. They have informed me that they will furnish subsequently the Ukalatama of
No,
the other
Mr.
respondent.
Sikdar, are you going to appear for 2 to 34
Yes, ma'am.
later on? Heard Mr. M.A. Sheikh, the learned counsel appearing on behalf of the appellant. Mr. A.R. Sikdar appears on behalf of the respondent number 1, who further submits that he have also been instructed to appear on behalf of respondent number 2 to 34. However, some time is required for the purpose of filing the Wakalatnama. List the matter immediately after the summer vacations.
Lord, your lordship would be pleased to take IA number 3258.
For what?
So, Lord, there was an interim order that is up to next date.
Huh?
So it may be continued.
My lord, we have
Interim order
objection,
may
my
be
lord.
continued.
We have objection. The matter has been, my lord,
my lord,
there
till
is
objection
second
is
round
filed.
of litigation, my lord.
My lord, my humble submission before your
Let
lordship. My
there be
friend will
hearing
file
on that,
objection.
my lord.
My friend will file objection.
Well.
But as already your lordship passed an interim order, that may be continued till hearing of the objection. As there is interim order already.
What is the order against SAO? Why you are filing an SAO?
Order, my lord, your lordship would be pleased
Order
to-
of remand?
No, my lord, not pray.
my lord, they have filed another suit, my lord, that was dismissed. My lord, on the point of red judicata. Then they, my lord, against that order they have come.
My lord, your lordship, our,
How can you file an SAO?
my lord, your lordship would be pleased to see.
Is it a SAO?
Because, my lord, your lordship,
did
we filed a petition under Order 21, Rule 97 and 101 of the 101 with Section 47.
Then?
So that was dismissed.
Then?
Thereafter, we go for appeal. Appeal was dismissed. Then we have come.
How are you filing SAO?
SAO, my lord, subject to correction, my lord.
There is no subject to correction.
My lord, we have gone through, my lord, from our reading, my lord, we filed this.
What reading? How is,
SAO
how is
against
an
order.
SAO maintained?
My lord.
SAO will, it has to come under the within the ambit of Order 43. That is the provision there against coming under an appeal path.
Well, it's a decree, my lord.
Then, if it's a decree, couldn't that be an RSA?
My lord.
It should be an RSA.
My lord, that registry did not raise any
No,
objection.
no. There's a difference out there.
My lord.
If it is an SAO, it will be taken on the basis of a, it will be treated
Appeal
in the
against
same
order.
manner as an order.
Against order.
It will be an against an order. Then the question of substantial question of law doesn't arise.
My
But
lord,
here it will be a
here in
substantial
this
question
case, my
of
lord,
law.
that the order was passed under Order 21, my lord.
So
Order decree.
if it is an order under Order 21, Rule 97 and 101, as per 103, it is a decree. And if it is a decree, it has to be an appeal. Therefore, you have filed an appeal, rightly. And against the appeal, it will be a second appeal. Then, how can you file an SAO?
My lord,
And I can't convert this also, because here the question will come of 40. Here the question will come is that you have to file a substantial question of law. And if you don't formulate the substantial question of law, I
your
can't help
lordship would be pleased to consider one thing. Page 36, my lord.
For what?
Page 36 to answer your lordship query.
Yes.
So that was not a regular appeal, my lord.
Understood. You have made a mistake.
That was a misappeal.
Whatever may be, but regular appeal or misappeal out there, it will be taken in the ground of as if it is under Order 41. It will be taken under Order 41 and Rule 96 or 104. But here you can't do it because this will come under Order 42 and 100. And here it has to have a substantial question. The nomenclature won't matter there, but nomenclature will matter here.
Well, I do agree with your lordship, but my reading was that it was a misappeal. That is why in this way it has been filed. And it is all, the appeal was admitted, my lord.
How can an appeal be admitted without a substantial question of law? How can an appeal be there? A regular second appeal or an SAO be converted to a regular second appeal, because the basic mandate of a regular second appeal is that you have to formulate or you have to mention which are the substantial questions of law as per 103.
Hello.
Withdraw with liberty, and this period should be and just file it and take the certified copy and file it. That is the only way out. You don't have any problem. You can file it by yourself. You have the wakalatnama. You can very well file it with the certificate. It has to be on a certificate. You don't have to call these people also. But without that, you can't do this. Is the problem.
But in that case, my lord, the question of limitation will come. That may be taken into consideration. Limitation will
That
come.
is what the time during filing of the instant appeal and the pendency of this shall be excluded while computing the period of limitation. That is the way out.
Well, I type that.
So you don't have a problem. It can be done on the basis of a certificate.
But here in this appeal, my lord, the substantial question is not complete.
That is why you cannot proceed in this manner. Not, you see, just for example, this misappeal which was done, they could have made it a title appeal. Because the grounds would be the same. It will be under 96 or 104. Oh no, it will be the same. But only the question of 104 is a discretionary and this is not. But with 100 and 104 it is, what do you call, in SM is atak patak. So you better withdraw and the period be, I will.
Yes, my lord.
And I will ask the registry to give you the copy of the certified copy of the order. But Mr. MHC, the learned
Your
counsel.
lordship, another thing I want to place before your lordship. Actually, it is an appeal under section 100. A read with order
42.
So, my lord, in that case, my lord, it is to be registered as a second appeal.
It has to be registered in RSA.
Correct.
That nomenclature is no problem. But I can't do it in this format.
Yes.
It is impossible to do it.
Substantive.
There will be a question of court fee. All these things will be there. Here the court fee is only 20 rupees or 15 rupees. Question for court fee will be there as per the valuation there. This will all change everything. But court fee also can be given. I can very well ask you to pay the deficit court fee. That can also be done. But I cannot allow this second appeal in this manner. It has to be because you see section 100.
Well, regarding court fee, my lord, one thing I want to place before your lordship. In the court below, my lord, in the Murshib level, we filed this petition.
You
On
paid,
petition
you
only
paid only 1 rupee 10 paisa.
10 rupees like this.
That is okay. But here you see what is required. In an appeal under this section, the memorandum of appeal shall precisely state the substantial question of law involved in the appeal.
Yes, my lord. That is correct.
So without that, you cannot. Okay, heard MHC, the learned counsel appearing on behalf of the appellant. Mr. A.R. Sikdar appears on behalf of the respondent number 1. It appears that the instant appeal, here also he has written 100. The court also has written 100. Couldn't have been 100. SAO can't be 100. It appears from the record that the instant appeal has been filed as a second appeal against order. From an appellate decree which arises out of an adjudication under Order 21, Rule 97, 99, and 101. The learned counsel appearing on behalf of the appellant submits that taking into account that it was an appellate decree, the instant appeal should have been filed as a regular second appeal under section 100, read with order 42 of the Code of Civil Procedure. He, however, submits that in view of the registration being made before the first appellate court as an appeal under section 104, read with order 43, it was mistakenly filed as a second appeal against order. He therefore submits he may be permitted to withdraw the instant appeal, and the period during which the instant appeal has been pending before this court be excluded while computing the period of limitation for filing the regular second appeal. He further submits that he may be permitted also to apply before the registry for the certified copy of the appellate decree, appellate judgment and decree, so that he can file the same along with
As well
in
as
the
original
in the
courts,
regular second appeal,
as well as original courts.
as well as the trial court's decree, as well as the first appellate court's decree, judgment and decree, so that he can file along with the second appeal. Taking into account the above, this court therefore permits the appellant to withdraw the instant appeal and gives the liberty to the appellant to file afresh a regular second appeal under section 100 of the Code of Civil Procedure 1908. This court further, taking into account the submission of the learned counsel for the appellant, observes and directs that a period during the period of pendency of the instant appeal, that is from that with effect from 4th of November 2022 till date, shall be excluded while computing the period of limitation. This court further directs the registry on an application so filed by the appellant to return the certified copy of the
Trial court as well as.
judgment. You have given both, na?
Yes, judgment and decree, or both.
One, two, I have seen it. Where is the other? No, I have not seen.
Judgment and order that is passed in.
To the certified copy of the appellate judgment and decree. I don't find it here.
Blood judgment and decree, your lordship would be pleased to see page 25 to 35. Miss case number 65. Judgment and decree.
Huh?
Your lordship would be pleased to see page 25 to 35.
This is not certified copy. There is a photocopy of a certified copy. Certified copy is here, only one.
In record.
Yeah. Of the appellate decree. Appellate judgment and decree.
My lord, one thing I want to point out before the lordship. From the very beginning, my lord, we are giving 10 rupees.
Where?
In trial court. Because, my lord, your lordship would be pleased to.
But Mr. Sheikh, you are such an experienced lawyer. I'm just asking you one thing. In a particular matter under Order 21, Rule 97,
my lord,
you will claim an independent right.
Yes, ma'am.
On the particular valuation of the property.
Hello.
Within the Court Fee Acts,
Hello.
Section 7 will apply. I'm not doing it a different thing, but within that apply. Because you will have a prayer.
My lord, my problem is different. How in the second appellate statement, I decide your lordship would be pleased to see page 9.
What does it say?
My lord, what happened, my lord? It starts like this. Miss J case number 65 of 2012. Arising out of title execution case number 3 of 2011. So, my lord, now an application under Order 21, Rules 97 and read with Section 47 of the CPC. Now, your lordship, my problem is this one.
47 won't come in.
My lord, that may be. Now, your lordship, how we decide the court fee at this second.
No. When you actually file an application under Order 21 Rule 97, you will be saying that I have an independent right. And as such, this is my right, and as such, you give me this declaration.
The value of the shoot will be like
absolutely.
That was not done, my lord.
It's okay, it is not done, but you whatever maybe, don't you pay whatever amount which is there. That's a different thing. These people also they don't know, but that is the requirement because it will be done as if it's a suit.
My lord. So, my lord, your lordship would be pleased to see the decree. Decree at page 62 possibly, my lord.
Just for example, tomorrow you have adverse possession.
My lord.
You are not a made a party to the suit. You come up and say that this is. You may very well ask your right, title, and interest on the basis of adverse possession. And that declaration, if you don't ask, you may be hit under order 22, order 2, rule 2. Expect.
My lord, regarding that court fee, my lord, what I have paid in the lower court, my lord, that I will pay.
If they don't ask,
because
you
my
pay
lord,
less.
From the very beginning, my lord, from 2012, as I have not fixed the value of the property. Now, my lord, at the high court level. Oblige.
30.
Maybe. Lordship, an IA has been filed for stay of order and judgment.
IA?
IA.
RFA?
RFA.
RFA admitted?
Admitted, your lord.
Why not stay till then?
In the main RFA, there is an order, your lord.
For what?
The last order depicts till the next date it is to be stayed.
Yeah, order dated
18/4/2022, your lord.
18/4, considering then all further proceedings. Now, what is the decree passed?
Decree is passed against the applicant. The applicant had, there was a memorandum of understanding between the applicant and the defendant regarding
Where is the decree?
Decree, lordship is taking the IA or the main.
I'm only asking you where is the decree?
The judgment starts from page 142.
Why you are making it like a second repetition, Mr. Das?
143.
Huh? You know what is required in the regular first appeal?
The decree, your lordship, starts from 175. only.
Where is the decree?
The operative part, your lordship, is 178.
177 is that, then
these judges also, they don't put it properly. What have been given? Money. Is a money decree?
the decree is, it is decreed against me, but the portion, the cost has been given against the applicant. Cost has been given against the applicant. Page 178 is the cost.
No. What have you been given actually? The decree.
No, they have not been given anything.
Huh?
We had filed a suit
For what?
for recovery of money of 25 lakh. That suit was dismissed. But while giving the dismissal order, a cost was imposed of 10,000.
Only 10,000. This appeal is for 10,000.
No. This is against the total judgment and decree, not against 10,000. Against the judgment and
you were a plaintiff.
Yeah, I was a plaintiff.
Why do you want to stay? For the cost.
For the cost.
I have no objection. I have no objection if it is.
Heard Mr. R.J. Das, the learned counsel, appearing on behalf of the applicant, Mr. N. Chaudhary, appears on behalf of the respondent. This is an application under Order 41, Rule 5, read with Section 151 of the Code for staying the judgment and decree dated 21/12/2021, passed by the learned court of the learned civil judge number 3, Kamrup Metro at Guwahati, entitled suit number 121/2017. In the said, by the said judgment and decree, the judgment, the suit filed by the appellant was dismissed. However, a cost of 10,000 was imposed.
10,042.
10,040.
42 was imposed. The instant appeal, the instant application is only for stay of that cost. Taking into account that the regular first appeal has been, the accompanying regular first appeal has already been admitted. This court is of the opinion that interest of justice would be met if the judgment and decree dated 21/12/2022 passed in title suit number 121/2017 insofar as the imposition of cost of 10,042 is concerned, it stayed till the disposal of the appeal. So I stands disposed. Second case, taking into heard Mr. R.J. Das, the learned counsel appearing on behalf of the appellant, and Mr. N. Chaudhary appearing on behalf of the respondent. The office note dated 12/6/2023 shows the records have been received, taking into account the above the list of matter for hearing in its usual course.
Deeply.
A record is received, so matrimonial fix for it.
Heard Miss
M. Malik.
M. Malik, the learned counsel appearing on behalf of the appellant, Mr.
A. Parvez.
A. Parvez appears on behalf of the respondent numbers 1, 2, and 3. It further appears that the LCR has been duly received, accordingly list the matter for hearing in its usual course.
Two.
This matter, a compromise petition has been filed, not the record.
Understood, but without the respondent, how can there be a compromise? They have to get hold of the respondent. A compromise petition has to be signed by both parties.
It has been signed by both the parties.
Then I get hold of them. His name is not shown here. There is only one respondent.
They have, the party has signed.
Okay. Your name?
C. Sharma.
Heard Mr. C. Sharma, the learned counsel appearing on behalf of the appellant. None appears on behalf of the respondent. Mr. C. Sharma submits that they have already filed an application for compromise for withdrawal of the instant appeal on compromise. Let the matter, let the said application be listed by on. You've already filed it, na?
Yes, sir.
On 26th of June. But get hold of the respondent counsel.
33.
Yes, why did you make a mention?
Because of if after the area rent has been paid during the before the trial in the trial court, thereafter no rent has been paid.
So you file an application.
Yeah,
Then why did you mention?
because there is no participant.
Who's that? Where was it? Yes,
I
no.
am the
So why don't you file that application? You can file. So why?
LCM में कैसे call?
Why? Miss Extend as the learned counsel appearing on behalf of the respondent submits that she is in the process of filing an application speaking on record that during the pendency of the appellate proceedings,
And here up to this proceeding,
during the pendency of the appeal as well as even in the original proceedings, the respondent, the petitioner, who is the tenant, have not tendered oblique deposit. 2 weeks time is granted.
much of that.
Obliged.
54,
Service awaited?
Yeah.
Service awaited. Yes, what is this review about?
I thought due to some personal difficulties, matter might not have that. So matter might be taken up on any other.
What is this so-called review?
Review petition.
Which matter?
I thought there is the judgment from the
Regarding?
provincialization of the service. That is my lord, the judgment order is 21 September.
Oh, that one. What happened till now? That matter. You only want one thing, that let those other some documents be also taken into consideration. Till now they have not taken into consideration. Nothing has happened. No contempt filed. The learned counsel appearing on behalf of the petitioner seeking for an accommodation. Accordingly, let the matter be listed when? Immediately after summarization.
Finally, death may be taken.
Immediate. This matter will come immediately after.
36,
Why the contempt matter is listed before? Yes.
The order which is violated that says 38 and 7.
So where's the respondent? Mister?
I do.
Your name?
I do.
Going to appears on behalf of them. Petitioner and none appears on behalf of the respondent. This is the matter again on 19th of July 2023. It is made clear that if the respondent is not represented on the next day, the instant proceedings, the instant case shall be proceeded with. In his absence.
38,
Await service report on respondent number 5.
I'm appearing for respondent 1 and 2.
It's going to appear
A
for
Bora.
respondent number 1.
39,
In section under section 5, respondent number 3 expired as per doc. So that name may be struck off. That's not sort of
6.
6 of it. In this case, it has been answered, but item number 40, same item number 40 is also there. Third.
Then
The others are third.
item number 40 and item number is same. Both are against the
same. Same lands are contiguous. Only
judgment is different.
judgment are
You are appearing for whom?
Item not 39, madam.
Not 40.
No.
4 and 5 are is also in respondent number 4 and 5 are also in item number 40.
Who is appearing 40?
Here is appearing for 40.
In this case, I have no objection.
How
21
much
days.
delay?
21 days.
And the second one?
Same, the judgment is fixed.
But second one, I have not the part.
Okay, item 39 and 14 leads the matter again on 19th of July.
Only respondent number
With the updated script. In the meantime, you appear. You will be appearing. Appear.
Forty-one.
Hmm. Unserved notice or AD card of have not been arrived. Learning counsel for the appellant has not taken steps by usual process. You have not taken usual process. Then take first steps. IA for condoning of delay.
Only 16.
Can't help it. It has to be served. You want to take trustee service? Where is it? Where do these people stay? The respondents, where do they stay? Where is it? You don't want to serve it? Okay. The appellant is further directed to take heard Mr. So-and-so, the learning counsel for the appellant, taking into account that the service upon the respondent number 1 and 2 in the interlocutory application have not been effected. The appellant is further directed to take fresh steps upon the respondent number 1 and 2 by way of registered post. This is the matter again on 9th of August. Take the steps immediately. The steps be taken within 3 days.
42.
Service complete. Service complete. Records. Records have come. Heard, Mr.
Yes.
And so the learning counsel appearing on behalf of the appellant. None appears on behalf of the respondent or call. It further appears that the records have been received. Accordingly, list the matter for hearing in the YouTube court. Await service.
I've taken the step, but not if it, it is still verified.
Mr. Ento, the learned counsel appearing on behalf of the appellant submits that steps have been duly taken. List the matter immediately after completion of service.
44.
Yes.
They're supposed to file the objection. No, Chief, we won't be filing any objections. We don't have any objections.
You have no objection. And why were you taking time in the morning?
No, Chief, may I submit that there was some lapse in communication with the client. Just now, my senior informed me that we won't be filing any objections. Okay, regarding the instruction, main appeal matter, but the main appeal because earlier just for hearing, that's by the direction of the court.
What is this 10304?
It was the injunction application.
Then you have no objection.
They don't have objection. Injunction was granted in our favor, madam. So my respect to the appeal may be hard for my hard. The appeal, second appeal, original appeal. May be listed for hearing.
Why don't you go before the authority? It's registry. Nowadays they have a proper list. Ask them to put it. Today, you see, I don't know. It's a 2012. Obviously, this will come into the.
Otherwise, basically, the matter
Well, I. Heard Mr. Siladitya, the learned counsel appearing on behalf of the applicant. The it appears on behalf
If we are not,
if Mia appears on behalf of the respondent.
what am I mapping on behalf of Mr. N. Bharat?
No acting business. Why you appearing then? None appears. We put it none. Are you in his chamber?
Yes.
Then what is it?
Okay.
Huh? Yeah? So how can I take the consent of a person who is no way connected? Mr. Ibuya appears on behalf of this court directed the respondents to file an objection. However, no such objection has been filed. Further to that, this court, by the order dated 10/5/2023, has directed the party to maintain status quo in respect to the suit property. It was further clarified that the suit property shall not be alienated and no construction work will be undertaken on the suit property until further. Taking into account that there has been no objection filed by the respondent, and also taking into account that the second appeal is pending disposal before this court is of the opinion that the order dated 10/5/2023 so passed by this court be made absolute till the disposal of the regular security. I accordingly stands.
Apply.
Who is appearing for that matter again? You're there? It matter. If I kept it for judgment today, you were there. You tell your senior, I'm not passing the judgment today. I'm picking it up 2 weeks. But asking to argue on one point as to whether on the date which was fixed for cross-examination, the court would have closed the defendant evidence. Asking to argue. Okay. Heard Mr. R. Hussain, the learned counsel, appearing on behalf of the appellate petition. None appears on behalf of the respondent. This court is of the opinion that before disposing of the matter, another opportunity be given to the respondents. Accordingly, list the matter again on 26th of July 2000. In name of the past 30th second. Yes, Mr. Gupta. What are you here? And you?
Mayor, Lord, please, your Lordship, I am in item number 6, Lordship. RSA, both the parties have settled the matter in a family settlement, Lordship. They have executed an agreement. May they are instructed not to part to the appeal, Lord.
Do you want to withdraw?
Lordship.
5 and 6.
6, item number 6.
You are 5. Let me first finish up 6. Heard, Mr.
S.H. Roman, Lord.
S.H. Roman, the learned counsel, appearing on behalf of the appellant, who submits upon instructions that as the parties have amicably resolved their issue, they do not wish to proceed. They have already amicably resolved their issue on the basis of a deed of family settlement dated
15/5.
There is the date.
First page, top of the first page, Lordship.
There is the first page date.
Top.
Top where? On the family, deed of family settlement dated 15/5/2023. The appellant does not want to pursue the instant appeal. Taking into account the state submission, the instant appeal stands closed on withdrawal.
Obliged.
Interlocutory application profile also stands closed on withdrawal.
Obliged.
Yes, Mr. Gupta.
I took the 5.
What is your matter?
But my prayer for prosecution of
You still have 5 minutes back. Okay. You may allow your matter. Yes,
Please.
what do you want?
Lordship. My prayer for prosecution of the witness video conference by stated.
Examination to video conference.
Yes. But the order said it is 34. The petition is at page 31.
I've heard the learning council considering the fact yes. Why do you want to do it by video conference?
Page 31 is the petition. Page 31.
Page 31. The above cases speak for cross-examination of Timothy went before the but he had the he could not. Now, is cross-examination permitted under the video conferencing rules? Then? No, there has to be permissible, no?
But my lord, with COVID period, and not the
Now there is no COVID.
Now that's not there, but with period that allowed. My lord, petitions are-
Cross-examination. Cross-examination, I don't think it will be allowed. They only allowed those people, those persons concerned who were there. They were allowed to come here. In the jail, they were allowed to not to appear in the court.
Not but evidence were also put.
Huh?
Evidence also put it.
It has to be on the basis of a video conferencing or some other. We have a video conferencing rules. Guwahati High Court rules video conference. Has this the rules been notified? No, it is permissible. You see, if you see this rule, any party to the proceedings or witness, save and except where proceedings are initiated at the instance of the court, may move a request for video conference. A party or a witness seeking a video conferencing proceeding shall do so by making a request in the form prescribed in Schedule 2. Request of form for it. Only thing is for final hearing only. The witness what they have done. Mr. Gupta, you kindly go through this at page 544 of this. Guwahati High Court rules for video conferencing for courts. We'll take it on some other day because what is required is there is a particular thing which requires to be done. How an examination of person is. Before doing that, he has to very well submit certain documents and affidavit that I am the same person. Huh? Yes, you need to go through. And as to whether these have been applied to the subordinate courts, because this witness comes normally, it will be also there's subordinate courts. Have a look at it. Okay. Third, Mr. A.K. Gupta, the learned counsel appearing on behalf of the petitioner, Mr. So and so, M.H. Ali, the learned counsel for the correspondent.
On the next day, we will file affidavit in opposition.
What? No affidavit. Don't believe it. Where is this affidavit in opposition? The learned counsel So the petitioner submits that there's the Guwahati High Court rules for video conferencing for courts, as was published on 18/5/2020. It submits that he needs to take appropriate instructions in the matter as to whether the said rules could be made applicable insofar as video conferencing of witnesses before the court of the additional district judge FTC. He submits therefore for an accommodation. List the matter again on 26th of June 2023. Interim order passed earlier shall continue till then.